एक मिनट इधर उधर आना। सर सर बच्चे बता रहे थे 135 सीनियर बच्चे लगन है उसमें तो सब टीचिंग नॉन टीचिंग में जाते हैं। पैसा अपने जितना ज़्यादा बोले जितना बोले बच्चे किया और तो 4-5 अब इसको जो बोलना है मास्टर अगर हमारे पार्टिसिपेंट्स 50 उसको 70 पैसा लेते चाय भी बोला चाय भी जो हमने बोल दिया कम बोलो तो बोलते कि कम क्या कोई आया इनका जो बेस्ट रहते मेरा क्योंकि ग्लास तो पानी नहीं चाहिए तो छोटी छोटी चीज़ें तो क्या बैच वाइज छोड़े लंच के बाद एक और सेशन उसके बाद कुछ गड़बड़ तो नहीं होगा और गेस्ट को
3 जण आहेत. त्यांच्या
हाँ जो लास्ट का जो सेशन था ना अंशी का बहुत अच्छा लगा काफ़ी अच्छा
Thank you.
याच्यावर
I request all the attendees to please take the seat as the session will start at any moment.
पानी का जार है आप रख सकते हैं ऊपर भी इसके नीचे सर के नीचे आप ऐसा करोगे तो एंकर
A very splendid morning to one and all present over here. I, Anushri Sachin Deshmukh, your street host for Technical Session 4, extend a warm welcome on the behalf of MLNGE Society, Manikchand Pahade Law College, Chhatrapati Sambhaji. Today, we embark upon the second day of the National Conference on Life, Law and Ethics, navigating the complexities of organ transplant, palliative care, and the right to a dignified life. An initiative by the Research Center in Law and Avishkar Research Club. It is my earnest hope that we continue to uphold the same enthusiasm, the spirit of intellectual deliberation, and the collective pursuit of knowledge as we embark in our earlier sessions. The theme of this technical session 4 is End-of-Life Choices, Navigating the Complexity of Euthanasia and Living Wills. This theme thoughtfully explores the intricate interplay between constitutional morality, human dignity, medical ethics, and individual autonomy. We are indeed privileged to have with us an eminent scholar and distinguished academician, Dr. Sharmila Gugge ma'am, Associate Professor at JC College of Law, as the esteemed resource person of this delegation. At this juncture, I humbly invite Dr. S.S. Karate ma'am to kindly introduce today's theme and set the intellectual tone for the session. I would also request ma'am to share a few words of appreciation to our respected resource person as a gesture of law, love, and mark of virtual felicitation. Over to you, ma'am.
Thank you, Anushri. Respected resource person of this session, Dr. Sharmila Gugge madam, all the faculty members, dear participants. I wish you all a very good morning, and I welcome you all in this fourth technical session, which is scheduled on the topic End of Life Choices, Navigating the Complexities of Euthanasia and Living Wills. Dear participants, it is rather a matter of great honor and privilege for us to welcome our esteemed resource person, Dr. Sharmila Gugge madam, who brings not only professional expertise but also personal insights into this subject, having already prepared her own living will. We are truly grateful to you, madam, for accepting our invitation and joining us virtually despite your busy schedule. Now, moving ahead regarding introduction about this topic, we all know that our life is very precious. Advancement in medical science have significantly extended the human life. There are many moments when, due to advancement in this science, it can prolong the process of dying rather than preserving the quality of living. As rightly pointed out yesterday by one of our resource persons, Dr. Vaidya sir, many times medical treatment may extend a person's suffering instead of curing them or healing them. So in such a situations, law and ethics shift their focus from merely keeping someone alive to respecting human dignity, personal choice and palliative care. This brings us to an important ethical and legal issue, that is end of life choices. There are some difficult but yet important questions, that is, can a person refuse life support system? How can dignity be maintained at the end of life? And who should make these decisions, whether patient, family or the doctors? So this topic brings together law, medicine, ethics and human dignity. While euthanasia raises debate about the sanctity of life versus autonomy, living wills offers a mechanism through which individuals can express their wishes in advance, ensuring that their voices be heard even when they are no longer capable of speaking for themselves. So as far as Indian context is concerned, students, these issues have gained constitutional significance, particularly with the recognition of right to die with dignity as important component of Article 20 of Indian Constitution. Honorable Supreme Court in Common Cause versus Union of India in 2018 upheld right to die with dignity under Article 21, legalizing passive euthanasia and living wills, particularly in the year 2023, with strict safeguards and against misuse. Now this discussion therefore not merely about death, but about choice, dignity and role of law ensuring a human end of life. Now studying and understanding euthanasia and living wills allows us to understand how the law navigates ethical complexity, safeguards individuals and upholds human dignity at the most vulnerable moment of our life. So today, our resource person Dr. Sharmila Bhuge Madam will guide us through these topics in a clear and insightful manner. I am confident that her discourse will definitely help all of us to gain better and practical understanding of these important end-of-life issues. With this, I will stop here. Thank you so much.
Good morning, everyone. Am I audible?
Yes,
Yes, ma'am, you're audible. Just a minute. Okay.
But there is a technical issue. I am not able to switch on my video. I do not know whether it is at my end or your end. So that's something very
Ma'am,
unusual.
just a minute. I have to introduce you and then you can start with your session.
Sure, my dear. Till then, I'll try fixing my video.
And ma'am, the PPT is at your end.
Yes. I shall do that. No.
Okay. Ma'am, can we ask you to rejoin the session so the technical issue will be solved?
Let me try.
Okay.
Yeah, I will leave and I'll get back.
Yes, ma'am.
Thank you, dear.
So, as we move forward with the session, It is my distinct honor and privilege to introduce our esteemed guest, Dr. Sharmila Bhuge ma'am, a scholar, accomplished academician, and distinguished legal illuminati. Dr. Sharmila Bhuge is currently serving as Associate Professor at the Jitendra Chauhan College of Law. Born in 1972, she pursued her early education partly in... Okay.
wait, हम भी ये बोल रही उनको ज्वाइन हो रही
Hi everyone, I have joined, but as I said, there is a technical error with the camera. So let me try doing this. Am I visible?
Yes, ma'am, you are visible.
Oh, just see if there is an echo. If there is an echo now,
Ma'am, can I request you to mute one device as you have joined from two?
I have muted,
Yes,
but still there is an echo. 1 second. Yeah, I have muted this device. Somehow on the laptop, my video is not available.
No, ma'am, now you are clearly audible.
Okay, so no echo.
No, ma'am, no echo.
Alright, wonderful. So I will hold the mobile in my hand
Okay.
and I will talk to all of you.
Okay, no issues, ma'am. So as there was a technical glitch, I will start again. As we move forward, it is my distinct honor and privilege to introduce our esteemed guest, Dr. Sharmila Bhuge ma'am, a scholar, accomplished academician, and distinguished legal illuminati. Dr. Sharmila Bhuge is currently serving as an associate professor at Jitendra Chauhan College of Law. Born in 1972, she pursued her early education partly in the United Kingdom and predominantly in India. She completed her bachelor's degree in English literature from Amravati University in 1995. She is a proud alumni as she pursued her LLB from Manikchand Pahade Law College in 2001, where she secured a place in merit list of Dr. Babasaheb Ambedkar Marathwada University. Demonstrating exceptional academic brilliance, she pursued her LLM in Constitutional Law from Dr. Babasaheb Ambedkar Marathwada University and topped the university in July 2003. In June 2004, she cleared the national eligibility test in her very first attempt. Her doctoral research on Article 21 of Indian Constitution, vis-a-vis right to die with dignity in the rarest of rare case, a critical study, earned her a PhD in October 2012. She had a rare distinction of receiving her doctoral degree at the hands of our former President of India, APJ Abdul Kalam sir. With over 23 years of dedicated teaching experience, Dr. Bhuge has served prestigious institutions including Government Law College and KC Law College, Mumbai, before joining Jitendra Chauhan Law College in 2009. She also serves as a visiting faculty for LLM at the Department of Law, University of Mumbai. An exceptionally prolific author, Dr. Bhuge has authored 11 books, edited 6 volumes, and published 42 research papers in reputed national, international, Scopus, and UGC care listed journals. She has delivered nearly 150 expert sessions across the nation and presented research papers around 10 national and international conferences. She is PhD guide at the University of Mumbai, a member of Board of Studies, convener for syllabus, revision of 3 years and 5 years law courses, a resource person for MOOC, Swayam, UGC refresher, orientation and 3 PhD courses. Her scholarly excellence has been recognized with numerous accolades, including the Women Academician of the Year Award 2023 by Rotary Club, the Global Inspiration Women Award 2022, Best Teacher Award 2021 in the category of Law, and lastly, the Research Excellence Award in 2021. Beyond academia, Dr. Guge has actively contributed to the society by filing public interest litigation before the Supreme Court of India and the Bombay High Court on significant constitutional and public issues. She has also worked extensively for legal awareness among tribal, rural communities, organizing camps on education, health, sanitation, women's rights, and social justice. Adding a creative dimension to her illustrious profile, she provides a consultation for the film Salam Venki, working alongside actor Kajol, and even appeared on the screen. Recently, she composed her lyrics for Constitution-themed song with renowned music composer Anu Malik, released on 26 January 2025. Dr. Sharmila Guge epitomized intellectual brilliance, unwavering commitment to justice, and compassionate service to society. Her journey is a testament of scholarship blended with social responsibility and creative excellence. So, ladies and gentlemen, please join me in extending a warm and respectful welcome to our distinguished guest, Dr. Sharmila Guge, ma'am. We welcome you, ma'am. On behalf of the organizing committee, I humbly invite Dr. Sharmila Guge, ma'am, to conduct an insightful discourse on the subject matter. Over to you, ma'am.
Thank you, dear, for the generous introduction. A lovely good morning to one and all the dignitaries on the dais, of the dais, dear participants, respected principal, ma'am, members of the trustee, and my own college, the MP Law College, where I have done my LLB. So it gives immense pride to say this, that I am an alumni of this institution, and I would have been delighted to come in person to deliver this session. But unfortunately, I was in Ratnagiri yesterday and I reached home at 2 a.m. last night. So it was not possible for me to travel today. So anyways, we can try virtual meeting and go ahead with the session. Just give me 1 minute. I will share my screen with all of you. Okay, I hope I made the co-host. Yeah. Okay, so now I'm sharing the screen. Alright. Is the PPT visible to all of you?
Yes, ma'am, the PPT is visible.
Thank you, dear. So once in a while when I ask something, if you can just get back, it will be good. Otherwise, because my video is having a problem, so I'm shifting myself from the mobile to the laptop.
No issue, ma'am, whenever you want.
Yeah, thank you so much. In case the slide goes off or my voice is echoing, please unmute yourself and let me know. Okay? So it's a pleasant morning. You have all had lovely sessions yesterday, I believe. And today we are going to talk on a very deep topic. Ending of life choices, navigating complexities of euthanasia and living in. So, this topic is very heavy to talk about, think about, but how can we make it a little lighter and simpler to understand? My intention today is not to make you people stressed with this topic or to make you feel gloomy at all, because I am an author of positive books. So I always believe it's not important how many days are there in life, but how much life is there in every day. है ना? जिंदगी कितनी लंबी है ये जरूरी नहीं है, but जिंदगी कितनी अच्छी है ये जरूरी है. So that's what we are going to look at. But before I go deeper, I will just have one small question, but because neither all of you are online nor I am in physical presence, I'll just give you the response without asking you the question. When one talks about understanding of such complex issues, there are three words in our life which we should know very well: information, knowledge, and wisdom. ये तीन शब्द बहुत महत्वपूर्ण हैं. Today, everybody thinks that I'm an informed person and hence a knowledgeable person. Law people most probably should be more aware about information, knowledge, and wisdom. I come to a lighter note and then to the serious topic. Information is what? Whatever we read, whatever we know is information. Knowledge is when you know how to use your information or when you transmit it in a particular manner. That becomes your knowledge. Wisdom is a step ahead. Okay. Now, if I ask, are you an informed citizens of India? Your answer will be, of course, ma'am. We are doing law, or we are professors, or we are lawyers. So everybody has a response that you are informed. Now, because you are educated, you are informed. But if you are in a village, you will still see that even illiterate person is informed thanks to his Android mobile. जिसके पास में Android मोबाइल है, वो YouTube पे जाके कोई भी information ले सकते हैं.
Excuse me, ma'am.
Yes.
Sorry to interrupt you, but can you just lower the volume of your mobile because your voice is echoing? That would help to solve the problem.
I have put it on mute, but
No, ma'am, just reduce the volume of your speaker of the phone so it won't echo in the laptop.
no, I have done that already. Or should I mute the laptop? Should I do that? Let me try. Let me try doing everything.
So, ma'am, we can do one thing. You can mute the laptop and you can talk on the phone screen.
One second.
Yeah, okay.
Now is it on? No.
No, ma'am. Yes, ma'am, it's all right.
It's alright.
Yeah.
But am I audible clearly?
Yes, ma'am, you are.
Because वैसे आवाज मेरी बुलंद है, बस माइक के इशू के कारण थोड़ी सी आती है.
No, ma'am. Thank you.
Thank you, dear. Alright. So, yeah, I was at the point: information, knowledge, wisdom. Information is something which anybody and everybody can have. Knowledge, when you know how to use your information. Wisdom, a step ahead. So, I have something for you to think. You can think and respond to yourself, or the sweet girl who's responding to me, she can give me the responses from two people. What's your name, beta?
Ma'am, Anushri Deshmukh.
Okay, Anushri, just ask the audience whether tomato is a fruit or a vegetable. Quick responses देके मुझे बताइए.
Do we have any answers on this? Yes.
Is tomato a fruit or a vegetable?
Ma'am, we have an answer. It is fruit.
Okay. Anybody else?
Anybody?
Respond किया?
Some of them are saying vegetables, some of them are saying fruits.
What do you think, Anushri?
Ma'am, we don't have an opinion on it.
No, you should. You're a law student. Tell me.
It's a fruit, I guess.
It's a fruit, you guess. Alright. Now, this is where understanding, knowledge and wisdom comes in picture. So, basically, tomato is used as a vegetable and a salad में खाते हैं और सब्जी में खाते हैं. But botanically, tomato is a fruit. So, those who said fruit, अपनी पीठ थपका लेना, आपका आंसर करेक्ट. So, tomato is a fruit. Now, knowing tomato is a fruit is information and knowledge. That you know tomato is a fruit. Not using tomato in fruit salad is wisdom. कभी खाया है आपने फ्रूट सैलेड में टमेटो? So my friends, knowledge is something when you know what to speak. Wisdom is something when you know what not to speak. Alright? So the problem is when you go deeper in life, like in the discussions of end choices, your information and knowledge somewhere needs to move to the step of wisdom. So as you grow in life, you don't have to understand what you should speak, but you need to understand what you should not speak. And that is why, as students of law, teachers of law, advocates, scholars, we all need to know the difference between information, knowledge, and wisdom. Life becomes better. With this, my friends, I take you to a serious discussion on life and death. So, what is the flow of my session? Briefly, I'm going to introduce, then talk about the forms of euthanasia, then the background and origin of living will, legal framework with case laws and some live examples in India, the living will across the globe, then how can you get your living will done, and a few recommendations from my side, and we conclude the session. And I believe, Anushri, I have 1 hour to talk or 45 minutes, whatever you say.
Ma'am, whenever you would like to stop, ma'am, we are very enthusiastic to hear.
So sweet of you, but I don't want to encroach on the paper presentations. So 1 hour maybe.
Ma'am,
Sheetal ma'am is also there.
50 minutes max.
Okay. I would also like to have if there are any questions from your end. So we will keep 5-10 minutes for that.
Yes, ma'am. Yes, ma'am.
Okay. Alright. So now, with this we go ahead. Please look at the image on the screen. और बहुत ध्यान से देखिएगा. On one side, we have a newborn baby, a very cute baby with little hands, tiny eyes, tiny body, and the joy. On the other hand, we have a human being who's in the hospital with several tubes inserted in his body from all angles. Now all of us know that when we have a newborn baby, सबके घर में होता है, भैया को बच्चा हुआ, दीदी को बच्चा हुआ, इसको बच्चा हुआ, मौसी को बच्चा हुआ, we are so excited. अरे हमारे यहाँ बेबी हुआ है, बेबी हुआ है, बेबी हुआ है. And the joy is celebrated, girl is born, pink balloons, boy is born, blue balloons, so excited. Exactly opposite is the phases of hospitalization. When someone from your family is in hospital with so many tubes inserted, you feel this is not done. I'll ask again a simple question which I won't take responses due to time constraint, but you can respond to yourself. Some of you may have gone for an MRI ever. अगर नहीं गए हैं तो बहुत ही अच्छी बात है, but unfortunately if you have gone for an MRI, in that big machine, when you go inside and you hear the loud noise of your ears, when you are there in that machine for like 25 or 30 minutes, you feel, अब खत्म हो गया यार, मेरे को बाहर जाना है. Because it's unbearable. That's the moment when you feel that life is not easy and you feel that I don't want this situation. Or when you go to see a patient in the hospital and you see the oxygen लगाए, the tube है, इधर ये है, वो है. You can never imagine yourself there. And that's the reason, my friend, we need to understand what is the meaning of life. The joy when we are born and the pain when we die. In this discussion of dedication towards end life choices, euthanasia and living will, there are a few things which are important. The first is the ethics, the medical ethics and the law at present. So the ethics signifies what moral values we have. Many people do not even appreciate talking about euthanasia. They completely say it is absolutely wrong. Medical ethics has its own moral principle, which the Hippocratic Oath is taken by all the medical professionals, and they have to abide by it while they deal with patients. The law, of course, it allows right to life with dignity and to Article 21 of the Indian Constitution. However, right to die with dignity does not authorize anybody to die. There are restrictions under the previous Indian Penal Code and the Bharatiya Nyaya Sanhita. Any doctor in India who tries to either bring about the death of the patient or causes death due to his negligence shall be punishable under the penal laws. Now, when you look at this image, my friends, and if I ask you a question, if any of your family member, your friend is a terminal critical illness with no hope of recovery to come back to normal life, if that person asks you, मुझे मरने दो, let me die peacefully, what will be your response? The questions are for you to what is the sanctity of life? What is meant by quality of life? Well, my friends, life is special and sacred, gifted by the God. Only God gives us life, and hence only God can take away life. Nobody else can take away life. And when we come to the quality of life, it means how good a person is. जैसे मैंने कहा, जिंदगी में कितने दिन हैं ये इम्पोर्टेंट नहीं है, एक दिन में कितनी जिंदगी है ये इम्पोर्टेंट है ना? So we have to see that जिंदगी is not lumpy, but it is happy. So what is euthanasia? पहले थोड़े जो basic words है वो clear कर लेते हैं. So those who are reading or listening for the first time about this discussion, they may get aware about it. Well, euthanasia is a word which is originated from a Greek terminology, which is a combination of two words, good, you, and thanatos means death. मतलब शांति से मृत्यु पाना, which means a peaceful death. Now, why was this suddenly a peaceful death? Because in the ancient era, we did not have medicine developed as we have today. So in the ancient era, people used to give births. Even in India, हमारे यहाँ क्या था? Ayurveda. And people used to treat with various leaves, plants, any Ayurvedic thing. Even today also we have that. But in that era, it was prevalent and we did not have the allopathic or the homeopathic medicines. These medicines, the Ayurvedic part, could not cure disease as the allopathic medicine today does. Therefore, in the Greek system, when a person was on deathbed with too much of pain, they came up with a concept: can we allow somebody to die peacefully? And that was euthanasia. But this, please mind it, don't get confused, whether it was available for a healthy person to say, मुझे मरने दो. No, it was available only for a terminally ill patient. So when I said sanctity of life, मतलब क्या? What life means actually? What is the value of life? Let me share something very personal with you today, which is quite painful for me. But nonetheless, the life has to go on, my friends. Sanctity of life, can be understood with what value the life has, how important the life is. We really don't understand this while we are healthy. Because हमारे लिए हमारा Wi-Fi होना ज़्यादा ज़रूरी है than the oxygen. So I always say on a lighter note to my students कि बेटा ऑक्सीजन बंद हुआ तो चलेगा, आपको बट Wi-Fi चाहिए, है ना? But that's not the reality, my friends. The oxygen is so important. You will realize only when you understand that someone very near to you is no more. So the sanctity of life is understood because if you have experienced unfortunate demise of anybody in your family, you can correlate कि अभी वो इंसान थे और अभी वो नहीं है. As I said to share with you, unfortunately I lost my father on 27th of January due to a cardiac arrest. So I met him just a day before, and I reached home at Mumbai at 1 a.m. and 3 a.m. I got a call that my father is no. So before leaving, I had given him medicine and a glass of water. Like this glass is half water. That day we drank the water and the glass was up. Next day when I went for his funeral, the glass was there, but the life was not there. So I lost one of the most dearest person to my heart, my father. And coincidentally, today is his birthday. So what is sanctity of life is very important. And to value that, you will understand it only when you have those emotions. So when we listen about euthanasia, when we talk about the euthanasia, it is not per se to say कि हम रास्ते पे आए थे हम मोर्चा करेंगे कि लोगों को मरने दो लोगों को मारने दो. That not at all is my intention. Neither is the concept. The concept is very sensitive, and the concept has to be looked upon in a very different manner. So when I was introduced by Anushri in a very wonderful manner, she read out that my doctorate was awarded in the hands of Dr. Abdul Kalam, and my doctorate was based on euthanasia. Now, just as I shared my father's example, he was fortunate that he passed away peacefully. Within a fraction of a second by a cardiac arrest, he was a doctor, oncologist himself. But my grandmother died at the age of 102, who was a lady of her dignity, very independent. She had specs at the age of 90, जो आजकल हमको 15-20 साल की उम्र में चश्मा लगता है. So the point is that she was that fit. She had her teeth in the age of 97. गन्ना खा सकते थे. I'm sharing this to give you an idea as to how healthy the woman was, how strong the woman was. But after completing her 100 years, her organs failed, and therefore she was hospitalized, and therefore she was required to give artificial life support systems. Her throat was slit from this side, और ट्यूब से उन्हें खाना दिया जा रहा. That was the day when I met her in the hospital, and I said, "Ki Aji, रास होगा." And my Aji said, "होगा, तुम्हें मला मरू का देखना है." That means, why don't you allow me to die? This was in the year 2005, and I was sapped by her statement that why don't you allow me to die? I came home, my friends, I thought, because by the time I was a professor teaching in Mumbai, and I thought that, okay, we have law, why doesn't it allow people to die? And I started doing my research on euthanasia. That is the foundation, and my PhD thesis, my little bit of knowledge, my books, I owe everything to my grandmother, because of whom I did this research. And my research was not emotional, it was a lot of research to understand why does a human being who has so much sanctity of life, importance of life, at a point says, "Mujhe marna hai." Why? That why is what we are going to discuss today. So, hope all of you are ready to listen. I'm sorry if I have made you emotional, but this is what euthanasia is. Not only emotional, but various facets of euthanasia. The first is, my friends, by now, you will have understood euthanasia means dying a peaceful death. Okay? Voluntary euthanasia means when it is performed on a patient, when the patient asks to die. So suppose there is a cancer patient and the cancer patient says that I am in too much of pain and please help me to die. That is voluntary euthanasia. Patient खुद होके बोलता है कि मुझे मरना है. Then we have involuntary euthanasia. Involuntary euthanasia talks about a person is in coma, but the person has somewhat time said that allow me to die or help me to die when I go in coma. That is involuntary euthanasia. Then we have passive euthanasia, which means removal of life support system. Now, removal of life support system has been legalized in India at present. We will also deal with the legalities. Only passive euthanasia is legal in India as of now. Active euthanasia is not legalized. Active euthanasia means where the doctor actively gives a lethal dose to the patient and patient dies. मतलब अगर मैं पेशेंट हूँ और मैं बोलती हूँ कि मुझे मरना है because of my pain, What the doctor will do, the doctor will take an injection, एक लैक्टिक ऐसे इंजेक्शन ले लेंगे और वो इंजेक्शन में मान लो मॉर्फिन का डोज या एनी अदर लीथल डोज एंड दैट इंजेक्शन देन द डॉक्टर इंजेक्ट्स इन द बॉडी ऑफ द पेशेंट विद द हेल्प ऑफ द पेशेंट्स हैंड, मतलब हाथ पकड़ के ऐसे इंजेक्शन देते हैं. दैट्स कॉल्ड एक्टिव यूथनेशिया, which is illegal in India, but some countries have legalized. Compulsory euthanasia is absolutely illegal on the entire planet. Compulsory euthanasia is a form which does not necessarily look at terminal illness, but says that kill a person who's not maybe fit or who has any illness. जैसे आपने हिटलर का स्टोरी अगर सुना है, so Hitler had killed around 5 lakh people in his kingdom, in his country, saying that oh they are disabled, they are of no use for my military. That is absolutely an act of killing. It is not mercy killing, it is not euthanasia. So my friends, when does voluntary euthanasia take place? When the person has full knowledge कि मैं क्या करने जा रही हूँ. That is voluntary. Non-voluntary euthanasia is when the person is incapable to express, but the doctor acts in the best interest of the patient. Assisted suicide is the example which I showed. Injection mar liya और patient को assist कर दिया to die. So that is assisted suicide. Mercy killing is absolutely illegal. Many times people confuse whatever is euthanasia is mercy killing. No. Mercy killing is what Hitler did. He had mercy on the people who were physically challenged, mentally challenged. That is not euthanasia. So mercy killing is not legal. It is a part of euthanasia because euthanasia is an act of mercy, but it's not an act of killing. Many a times when I talk about these things in person or in live sessions, people ask, "Ma'am, क्या difference है? Kill तो वैसे भी हो रहा है ना patient." There is a difference, my friends. It's not killing, it is allowing somebody to die. So that difference one needs to understand. Well, coming to the modernization of medicines. Today, because the society has developed so much, the medicine has developed so much, we have so many things which can keep a person alive without naturally being alive. What we call as the artificial life support system. So we have advanced painkillers, we have lethal dose, we have terminal illness, we have persistent vegetative state. What do you mean by persistent vegetative state? This is what most of the discussion is around, where even we talk about Aruna Sharma's case, persistent vegetative state. Persistent vegetative state means when a person becomes like a vegetable. To give you a simple example, आप लोग सब्जी खरीदते हैं या आपके पेरेंट्स सब्जी खरीदते हैं? So एक एग्जाम्पल ले लीजिए कि आप सब्जी मंडी गए हैं. If it's औरंगाबाद, this is the good मंडी where there is the सब्जी मंडी, and you go there and you pick up a cauliflower, एक गोभी का गड्ढा आपने ले लिया, फूल गोभी का. आप उसको पूछते हैं कि भैया कितने में दिया? You take that cauliflower and go home. Now you purchase the cauliflower. Today is 28th of February. You purchased the cauliflower today. When was it plucked from the farm? Maybe yesterday. 27 को वो गोभी का गड्ढा अपने प्लांट से रूट से निकाला गया. Life has ended. When has the cauliflower died actually? When it has been uprooted in the farm. जैसे ही खेत से उसको निकाला, उसका लाइफ खत्म हो गया. You buy that gobi ka gata, you come home and you keep it in the refrigerator. Now the cauliflower is in the refrigerator. Your mother says, "अच्छा आज गोभी नहीं बनाते हैं." So the cauliflower comes out of the refrigerator on 1st of March. You make the sabzi and you eat, and you feel the cauliflower was fresh. My friends, the cauliflower died on 27. You are consuming it on 1st or maybe on 2nd or 3rd week, eating vegetables in the refrigerator. Cauliflower is in persistent vegetative state in the refrigerator. अब ये सुन के ये मत बोलना घर जाके कि मैडम ने ऐसा एग्जाम्पल दिया, आपका हम जिंदगी में गोभी नहीं खाएंगे. ऐसा कुछ लगता है ना, ठीक है? This is just an example to tell you that the life uproots at a time and then it is kept in the fridge and you feel it's alive, just like we humans. When we are kept on a ventilator, we actually have lost our life, but the artificial life support system keeps us in a persistent vegetative state and we feel people are alive, but they are actually artificially alive. आगे चलते हैं. There are several diseases today which have come up, which were not there in the ancient era. So we have diseases which lead to terminal illness. See, I repeat again, euthanasia is not something कि आपको सर्दी जुकाम हुआ और आप बोले मेरे को euthanasia चाहिए, या आपकी गर्लफ्रेंड छोड़ के गई, आप बोल रहे हो मेरी तो जिंदगी जीने लायक रही ही नहीं, और यू फील अरे मेरी बहुत झगड़ा करती है, जीना ही नहीं, और यू फील सारा जॉब ही नहीं मिल रहा है, जीना नहीं, or I got less marks in my this semester and my other friend got to let me die. These are circumstances which are absolutely different. We talk about euthanasia only when a person has terminal illness or life-threatening disease which has no recovery. ठीक है? ये concept clear रखिएगा. So there are many diseases, Alzheimer's, muscular dystrophy. You can see the image very clearly, and you will understand that how difficult it is. I have also put Kajol's images of the movie Salam Venki, and as mentioned in my CV, I wrote the courtroom dialogues for Salam Venki, and I played a 1-minute role on insistence of Kajol and the other team members. So Vishal Jethwa was playing the role of the chess leader. Unki story hai aage. These are the diseases, my friend, which make a person enter the terminal illness phase. This is the story of the chess player K. Venkatesh, which was depicted in the movie Salam Venki. I don't know if anyone of you have watched the movie, but if not, you can watch it. It is something sensitizing people and very relevant to the theme of this conference, which talks about organ transplantation, donation, and life-end decisions. So who was Venkatesh? Venkatesh basically was a lovely child from his childhood who unfortunately was suffering from a disease called DMD. क्या होता है ये? Duchenne muscular dystrophy. Since childhood he had that, but his mother Sujata was a very strong lady who managed him very well. He was the chess player at the age of 25, but his condition worsened. क्या होता क्या है muscular dystrophy में? Muscles सारी body के give up कर देते हैं. तो हाथ हिलता नहीं है, पैर नहीं चलते हैं, बोल नहीं पाते हैं, बिकॉज ये जो मसल्स हैं अपने चीक्स की मसल्स ये काम नहीं करती हैं, स्माइल नहीं कर सकते. सो द पर्सन बिकम्स लाइक अ बॉल ऑफ फ्लैश, मतलब बेड पे पड़ा रहेगा जैसे कोई जिसे हम बोलेंगे बॉल फ्लैश पड़ा हुआ है. सो इन 2004 Venkatesh condition worsened and Venkatesh was a very bright child. He said, Mama, before I die, I want to donate my organs. So he filed a plea in the Andhra High Court for euthanasia that allowed him to die, and so that before he dies, allowed him to donate his organs. So the matter was filed, the legal battle started. He requested for withdrawal of life support system. The court rejected, saying there is no law on euthanasia in India. So we cannot allow you to do that, and we cannot allow you to donate your organs. See, a person can donate organs when the person is brain dead, right? But it was not allowed. Finally, Venkatesh sadly died on 17th March 2004, and he could not donate any of his organs except his eyes. Because as we all know, we can donate our eyes even after 72 hours after our death. But other vital organs are not much useful. We can donate our skin, our eyes and our hair after our death. But other organs we need to donate when we are brain dead. But that didn't happen. Now this issue was kind of a debate which was sparked when Venkatesh lost the battle in the court and he died. Salam Venki movie is based on this particular story of Venkatesh. Now let me take you to the laws which govern euthanasia across the globe. So my friends, Netherlands is the first country which has legalized euthanasia in 2002. Then we have many states in United Kingdom. Oregon legalized assisted physician suicide in 1997. Then Belgium, Switzerland, Luxembourg. Rest of the countries are still fighting to have any form of euthanasia. Let me share with you, Switzerland एक ऐसा country है जहाँ पर tourist euthanasia allowed है. What does that mean? That means any person from any country can visit Switzerland. In Zurich, there is a clinic called Dignitas. You go there with medical certificates of doctors and you say that I am suffering from terminal illness. These are my medical certifications. Help me to die. And you will either be given an injection and you will die peacefully, or there are mechanisms. जैसे अभी मैं बैठी हूँ, आप लोग भी चेयर पे बैठे हुए हैं. There was a machine which was invented in United Kingdom by a doctor, and then he was punished for that, of course. So he invented a machine जो अपना chair का हाथ होता है ना, the arm chair. On the handle of the chair, he put a needle. The needle had poison in it. Okay. Below the needle there was a lethal dose injection. And suppose I'm sitting on a chair, ऐसा हाथ आप chair पे रख रहे हैं, then the needle goes in the hand. The minute the needle goes in the hand, I will die. So this chair was invented in UK, and then finally the doctor was punished for this because in United Kingdom euthanasia is not legal. So by now you are aware what are the concepts of euthanasia: voluntary, involuntary, passive, and physician-assisted suicide. This is what our debate is rotating around. There are some medico-legal aspects of euthanasia. So, the minute a doctor comes in picture, the doctor has his medical ethics as per the Hippocratic Oath. And what are the medical ethics? Autonomy of the patient, beneficence of the patient, non-malfeasance, and doing justice to the patient. मतलब patient को autonomy है. The patient has a right to say, I don't want this treatment. But the doctor has to see whatever is done is in the best interest of the patient. The doctor has to see that he doesn't do any illegal act, and the doctor also has to see that he does justice to the patient. So, these are the medical regulations. अब law की तरफ चलते हैं. What is the law? Well, my friends, euthanasia has its parameters with law. On one hand, we have the patient's rights, like how Ankhan says, I, me, and myself. Like that, we all have me, my body, my right to refuse, my consent to treatment, and my wish. So when I say this, I can tell the doctors not to treat me for anything which I don't want. On the other hand, if I say, allow me to die or help me to die, the state comes in picture. और state का कर्तव्य क्या है? State का कर्तव्य है to protect the life, to protect the sanctity of life. So, right to privacy, right to die with dignity comes in direct conflict with protection by the state. So, quality of life versus value of life. When somebody says, kill me, is it that easy? No. Euthanasia, suicide, mercy killing, or assisted suicide, all these components are done by various courts of various countries, leading to one common response: no doctor can deliberately kill a patient, because the concept of euthanasia rotates around individual interest, individual liberty, and individual right. As I said, I, me, and myself. So it's my right, it's my body. I cannot allow anybody to do anything against my wishes. And when I say, help me to die, the state will say, no, it is our duty to protect the life. Right to die is not a concept under right to life under Article 21. But there's something very interesting in this. Concept of euthanasia is compared with concept of abortion. As you all know, most of the countries have legalized abortion under certain medical conditions. Like in India, Medical Termination of Pregnancy Act is a law which governs abortions in India, and women are allowed to abort the fetus if the fetus is abnormal or it is a threat to the woman's life within the prescribed time limits. Okay. Argument of people who advocate euthanasia is a mother decides about the life of the fetus, which is not her right, but still she does. In euthanasia, the person himself or herself decides, but still is a weaker point. मतलब fetus में जान होती है और fetus को legal recognition भी है. Fetus has a legal personality. Still, the mother decides on behalf of the fetus. But for euthanasia, even if the person decides, the law will still vote. And that is when I will also like to share with you as to how the society has changed with regards to abortion or reproductive rights. Here I'll tell you a short story. एक मार्गरेट नाम की नर्स थी, ठीक है, इनका नाम था मार्गरेट सैंगर. दिस इज फ्रॉम यूनाइटेड स्टेट्स ऑफ अमेरिका. अगर किसी को नींद आ रही है सुबह सुबह तो आप खुद के देख लीजिएगा स्क्रीन की तरफ या मेरी तरफ. In live sessions, I make a point that I interact a lot so that I can see that people are not dozing off early morning. But unfortunately, it's a virtual session, so I can't reach out to you directly. Well, Margaret Sanger was a 9th child born to the 12 children of her parents. मतलब 12 बच्चों में से ये नर्स 9th थी. जब ये छोटी थी तब इन्होंने इनकी माँ से पूछा, मम्मा, why do you have so many kids? Because they were poor. And so she wondered, why so many children? The mother said, darling, we do not have any control over our reproductive system. And therefore, the minute we have a physical relation, we have a child. So Margaret Sanger, from her childhood, thought about this, that how can I control women's reproductive system? She grew up to become a nurse, and after she became a nurse in 1910, Margaret Sanger started a movement of family planning. To control the reproductive system of women, Margaret Sanger set up a first birth control clinic in 1960. And for this, she was arrested. क्योंकि उस वक्त यूनाइटेड स्टेट्स में कॉन्ट्रासेप्टिव पिल्स देना या women की reproductive system को control करना was illegal. And therefore, Margaret Sanger was arrested that how can you prescribe medicine for not having children? Abortion is illegal. After Margaret Sanger completed her punishment, she went to Australia. She did a lot of research and she came back in 1923 and she established a research bureau whereby she compelled the Congress government to say that no, Margaret Sanger is correct and women have the right of autonomy, they have the right to control their reproductive system, and hence 1950 onwards, United Kingdom had a mushrooming of birth control clinics, contraceptive pills. Point is, किसी ज़माने में contraceptive pills देना एक offense था. Today, even a country like India distributes contraceptive pills free of cost for women to control their reproductive system. So there is a liberty right that every woman has कि मेरा reproductive system है, मुझे क्या करना है मैं decide करूँगी. But a terminally ill patient doesn't have that liberty. So let's take a glance at what is the debate of euthanasia living wills in India. Well, my friends, because euthanasia is surrounded with uncertainty, today the concept of living will has come. Will is something which all law students and law people know. जिसे हम मृत्यु पत्र कहते हैं, है ना? What is a will? Not a living will. A will, मृत्यु पत्र, जिसमें लोग अपनी प्रॉपर्टी के बारे में लिखते हैं कि मेरे मृत्यु के पश्चात मेरी प्रॉपर्टी, मेरी वाइफ, मेरा बेटा, मेरी बेटी, मेरा पोता पोती इन्हें दी जाए. So a will is a document which states as to how the deceased would like to bequeath his property once the person is no more, he becomes a deceased. So a will comes in existence after the person dies. Living will is something which comes in execution, which the person says what are his or her wishes and is executed during the lifetime. So living will is one document in which you give advance directives that in case I go in terminal illness, what should be done to me, what treatment should be given to me, that is living will, जिसे advance directive भी कहा जाता है. The laws which govern living will are countries like United States, various states in USA, California, Washington, then Belgium, Luxembourg, Germany, many countries. I will also take you to a case called Terry Chivalry before we go to the draft of Terry Chivalry. She was a beautiful girl with a lovely heart, happy to live. Unfortunately, she had a relative arrest in 1990 and she became terminally ill. Her timelines by God teaching. Just look at the timelines. She had a cardiac arrest in 1990. Until 1998, she was on a feeding tube. So for 8 years, she was on a feeding tube. The husband says that I want to remove Terry's tube and I want Terry to die peacefully. Terry's parents said, no, we will not allow you to do that to our daughter. Let our daughter live natural life as much as she wants. The legal battle started for 7 to 8 years. Many courts from the lower court to the high court of Florida, the couple, the parents and the husband fought. Finally, the topmost court said that we have to respect the wish of the husband. There is no point making her live like this as a almost a dead person. She had no sign, no expression. So let us remove the life support system, which was the tube, the feeding tube, which was through her neck again. Feeding tube निकाला और 15 दिन के अंदर टेरी की मौत हो गई. Terry's parents challenged this, and this sparked a debate in the entire United States that what is the extent of law to allow a person to remove the life of the support system. And that is when euthanasia became a very common theme in debates and discussions and in the courts. And that is exactly the point where people thought that Terry को हार्ट अटैक आया और Terry 8 साल वो ट्यूब के साथ जिंदा रही otherwise. If Terry would have written a document that if I go in a vegetative state, this is what I decided, then her husband and her parents would not have been required to fight so much. And easy हो जाता. That is when the advance directives came in picture. So we have to have a balance between the medical and the legal. Advance directives talk about the living wills. But all these things have their advantages and disadvantages. Also the unintended consequences. Because patients are vulnerable, people have economic interest. Somebody may say that Dr. Sharmila has made a living will where she doesn't want to be put on life support system. Can he take living will? And when I go in a state of coma, either of my child will produce and see that I die immediately. So the children or the relatives or the doctors may have some vested interest. And therefore, it is important to have proper laws laid down. To run through you, to quickly through some cases in India on euthanasia, one was Maruti Shripati Dubal's case. Maruti was a constable basically in the police department. He was charged with certain charges, arrested. And then after he finished his term, he was acquitted. Maruti felt, भाई जब मैं पुलिस ऑफिसर था, इतना तो बहुत प्राउड था, मेरी इज्जत थी. अब तो लोग इज्जत ही नहीं करते हैं. So he thought, now my life is not worth living. He went to the municipal corporation office. He poured kerosene on him, and he said, मुझे मरना है. So he was about to lit himself to fire. That was the time when the law said you cannot commit attempt to suicide, which was punishable. So again, Maruti was arrested and he was put behind bars. So Maruti then filed a writ petition in the Bombay High Court saying that if I have a right to die, I also have a right to die. So let me die. If I have a right to speech, I have a right to silence. Similarly, I must be allowed to die if my life is not worth living. His contention was Article 285, which bestows upon us right to life with dignity, also should include right to die with dignity. Justice Samant was the deciding authority and he said, correct, right to life must include right to die. Then came the case of P. Rathinam in the Supreme Court and the Supreme Court also said right to life must include right to die. But when the Gyanbar case came up before the Supreme Court said we cannot allow people to die as a part of Article 21. The court never dealt with euthanasia in all these three cases. Please note, यहाँ पे कोई भी terminally नहीं था. So the court pointed out that euthanasia is something which talks about terminal illness and hence right to die is not a part of right to life. Then came Aruna Sharpak's case, which was a really case of euthanasia. This is Aruna Sharpak, a beautiful young girl who joined KEM Hospital in 1973 as a staff nurse, ended up her life in 2015 after 42 years of coma. So Aruna was in coma for 42 years. इनकी story short में ये है जिनको पता नहीं है. She was born in 1948 in Karnataka, joined KEM in 1973. She was a staff nurse, very fond of cleanliness and very fond of dogs. So right behind her workplace in KEM, there was a shed. पीछे एक shed होता है और वो shed में कुछ कुत्ते रहा करते थे. And Aruna used to feed those dogs. उनको कुछ bread, चपाती डालती थी. Valmiki was a sweeper in KEM Hospital. So Valmiki was supposed to clean the dogs area. अब एक दिन वाल्मीकि आया और वाल्मीकि ने अरुणा को पूछा, Can I get a half a feeding? Aruna said, No, Valmiki. आपने मेरे कुत्तों की जगह साफ नहीं की. आप वो साफ करो, मैं आपको छुट्टी नहीं दे सकती. Valmiki had that anger in his mind. Next day, Valmiki entered the hospital. He went to Aruna's changing room. हाथ में क्या लेके गए? कुत्तों की चेन. उस जमाने में कैसी चेन होती थी? आयरन के बॉक्स होते थे. देखा होगा आपने कभी कुत्तों की चेन, लोहे की जो होती है. He took that chain. He entered Aruna's changing room when Aruna was changing, and he attacked Aruna with that chain. यहाँ से लेके, अगर मेरा चेहरा आपको दिखाए, गर्दन से लेके यहाँ तक वो चेन इस तरह से पूरे उनके सर पे लपेटी गई. So the iron chain with the iron box entered the nervous system. आप imagine कर सकते हैं एक लोहे की चेन कुत्ते वाली अगर गर्दन को लपेटी गई, ब्रेन और गर्दन को, तो वो लोहे के जो स्पाइक्स थे वो पूरे दिमाग में चले. Aruna fell down in a pool of blood. वाल्मीकि वहाँ से भाग गया. जब दूसरी नर्स वहाँ पे आई तो उन्होंने देखा कि अरुणा यहाँ पड़ी हुई है, उनके दफ्तर में उन्होंने उठाया. The dog chain entered her nervous system so badly that Aruna entered a state of coma at that very moment. After that, she lived 42 years as a persistent vegetative state patient. When Aruna died in 2015, there was a debate which was sparked. Pinky Nirani filed a public interest litigation in the Supreme Court that passive allowed euthanasia to Aruna. The Supreme Court directed the KEM Hospital to set up a team to give their opinion. क्या हम अरुणा को euthanasia दे सकते हैं? The team said no. Even if Aruna doesn't speak, she opens her eyes, and we don't want her to be euthanized. Then the Supreme Court said in 2011, India legalizes passive euthanasia. मतलब अगर patient life support system पे है, तो today the doctors and hospitals can remove the life support system and allow the patient to die peacefully. This is the legal situation. Active euthanasia is absolutely illegal. with regards to euthanasia. I'll give you some more examples quickly before I stop. Some examples are when Dr. Abdul Kalam sir was the President of India. There were people like Rajan, Rathina, who wrote letters to Dr. Kalam saying that we are absolutely in a pathetic state of life. We are having no financial means for medicine. Please allow us to die. Give us euthanasia. But as it was not legal, Dr. Kalam rewrote letters and refused. There was an interesting case of 4 children having DMD, muscular dystrophy, जो मैंने अभी वेंकटेश का केस आपको बताया. एक NMRS hospital का भी था जिसमें many patients had returned letters. But let us talk about the 4 children. Parents were senior citizens. 4 children, they were not minors and returned children, but they were major, all of them. चारों के चारों को DMD था. चारों के चारों बच्चों को उठा के टॉयलेट को लेके जाओ, उठा के टॉयलेट से लेके जाओ, उठा के कपड़े पहनाओ, उठा के खाना खिलाओ. And they were completely bedridden. And these were poor people. They did not have money to go to private hospitals, or there was no cure for DMD in government hospitals. So they wrote a letter to Dr. Kalam कि हमें मरने दो, हमारे बच्चों को मरने दो. No parents will see this, but it was a compulsion. However, as it was illegal, Dr. Kalam did not go out. So my friends, why do we need legal wills, living wills? Because today passive euthanasia is legalized. मतलब डॉक्टर लाइफ सपोर्ट सिस्टम निकाल सकते हैं, बट उसमें भी डॉक्टर्स को रिस्क होता है. As I said, suppose unfortunately ever I go in coma, and now the doctor, as per the law of the land, has to remove the life support system. I have a daughter and a son, and my daughter says no. मेरी मम्मी को लाइफ सपोर्ट देते रहो जब तक वो जिंदा है, और मेरा बेटा बोलेगा नहीं. मम्मी इतनी इंडिपेंडेंट थी, मम्मी को पसंद नहीं था लाइफ सपोर्ट निकाल. What will the doctor do? Will he listen to the daughter or the son? And if he listens to either, the other person can file a case. If the doctor says don't remove, and if the son says remove, and the doctor removes, then the son can go and file a case. So to avoid that, we have the concept which protects the person's autonomy as an advance directive. So the background of it had its origin in 1969 in United States of America. A lawyer by the name Louis Cutler, he envisioned that what happens when people are on deathbed, they cannot express their wishes, and therefore we should have a document which states that what should happen to you when you are not in a condition to speak for yourself, which is also now protected under Article 21. Well, in India, after Agma's case, there was another case filed in the Common Cause versus Union of India in 2018 before the Honorable Supreme Court of India, which insisted that advance directives be legalized in India. Any and every person who is above 18 must have a right to note down. जैसे मृत्यु पत्र में लिखते हैं कि मेरे मृत्यु बाद मेरा सोना, मेरा फ्लैट, मेरी खेती इसको दी जाए, उसको दी जाए. The law respects the wishes of a person after he is dead. Certainly the law can respect the wishes when we are alive. So I can write it down that when I go in coma, this is what should be done to my body. That is a living will. So the living will includes, first it should be returned, it should be signed by yourself, the witnesses, and the executor also must know. Now, what is the system of living will which was legalized? In 2023, the Supreme Court laid down guidelines that how you should have a living will. As I said, it is an advanced directive. The content should be clear. What is your desire if you go in a persistent vegetative state or coma? Simple Bhasha. Who will execute? So at that time, in 2023, Supreme Court said that every person who makes a living will must get it executed through a judicial magistrate first class. Once the judicial magistrate first class accepts, then a copy be given to the doctor who is your physician, copy be given to your family members and your witnesses, and that is the registration of living will. अब इसमें practical difficulties क्या आई पता है? I faced it. I made my living will in 2023. I decided area called Academy West in Mumbai. Today I am at home because I came late night and I had these sessions in Trashpur College or my office. So I'm sitting here in Kalpuri. The nearest magistrate court I have is Wood. So I went to the Goregaon magistrate with the copy of this judgment and my living will. And I said, Your Honor, you have to accept this. Judge साहब डर गए. Judge साहब बोले नहीं ये ऐसा कुछ मैं नहीं लेता. So the judge did not have any idea. What is this? And the judge said, I will not accept. This is a judgment. But we will accept only when we get a notification from the judiciary that we are authorized to accept the living will. And he refused. Then again I wrote a letter to the Chief Justice of India stating that my living will is not being accepted. Meanwhile, there was changes in the procedure. In 2004, again the Supreme Court made changes and took off the component of signature for acceptance by Judicial Magistrate First Class. So at present, all what you have to do is prepare a draft of your living will under the guidance of your medical professional, your physician, get it signed by the gazetted officer or a notary, have two witnesses, attach a certificate of soundness of your mind or physical fitness certificate, then give a copy to the guardian, which will be nominated by the state, give a copy to the municipal corporation, give a copy to your physician, to your executor and to your witnesses. Thereafter, Mr. Nikhil Datar also made his living will and filed this petition in the Bombay High Court because the Supreme Court said that there will be custodians which will be named. जिस custodian के पास हमारी living will की copy रहेगी, जैसे मृत्यु पत्र हम register करते हैं and the registration office has the copy. Like that, living will का copy किसके पास रहेगा? So the living will copy will be given to the custodians. So now the Maharashtra government has nominated 417 custodians as per the guidelines of the Supreme Court. So you can give your living will to the custodian. Well, what can living will help or how can living will help? I will request each one of you, irrespective of your age, ये मत सोचना कि हम तो 20 साल के हैं 25 के हैं हम कहाँ कल मरने वाले हैं हम living will बना. You must always make your living will. You must always inspire your parents, your family members, your neighbors to do so because that will help to solve many legal issues which will come up in the future. So you are required yourself understand that you will release your medallion. जैसे अगर बेटा बोलता है कि लाइफ सपोर्ट निकालो, बेटी बोलती है मत निकालो. You resolve these issues. You protect your right to autonomy. You protect your self-respect. This is the copy of my living will. I have tagged my name and address. It was done on 9th of February 2023. So it is done under the consultation of a medical professional who is my family doctor. What have I bequeathed or what have I mentioned in my living will, my friends? In my living will, I have mentioned that I do not need life support system beyond 72 hours. If I go in coma or a vegetative state, I have donated my entire body for medical research. My all vital organs should be taken for medical research. My skin, my eyes, my hair, everything should be donated. I do not believe that a body should simply be burned into ashes. I respect the Hindu rituals. However, I believe that इंसान को हमेशा इंसान के काम आना चाहिए, चाहे वो जिंदा हो या चाहे मरने के बाद. So even when I die, I want people to be helped by my body, by my organs. And I request all of you also to see that if you can help people. I hope you all are aware that in India there is extreme scarcity of donors. We have so many people on the list who need liver, who need kidney, but people are not ready to donate, who need heart, but people are not ready to donate. So at least when we become brain dead, unfortunately, if we do, vital organs before they go waste and they go into ashes. So it's a humble request from my side to see that we take up this lead and we sensitize people to have their living wills and to donate their organs. I have pledged my eyes, I have pledged my skin, I have pledged my all vital organs. The countries which have legalized living will, there is a list. All these countries, United Kingdom, Canada, USA, Germany, France, Switzerland, all these countries have legalized the living wills as advanced directives because it is a situation which will help the doctor to resolve the dilemma. मैंने एक लाइफ सिचुएशन यहाँ पे दिया है. If there is a patient of 72 years old by name Mr. Sharma and he is in persistent vegetative state and doctors opine that nothing can be said about the recovery. If this Mr. Sharma has a living will which says कि मेरे को artificial system नहीं चाहिए, immediately the doctors get relief. Life support system निकाल के patient को discharge दिया जा सकता है and the family can easily overcome the emotional stress. कि इन्हें क्या करें, मैं घर लेके जाए या रखें hospital में. Therefore, my recommendation is we have to balance the conflict between the medical and the legal aspect. We are the educated section of the society who has to create awareness, educate society about it. You yourself be a vigilant citizen, spread people importance of life, but at the same time, importance of dignified life before we pass out. So my friends, quality of life is very important. Best interests of patient also equally important. But in the debate of euthanasia, I will say, living will is not about death. It is about how we value our life when the life loses its meaning at the end phase. And therefore, as we welcome the return birth in the family, let us even respect the chairman. So, let us lead the society in the required manner. We must have a dignified birth and a dignified exit. I would say, amalgamation of law and medicine can be desired to give a dignified exit and dignified treatment to patients. With this, my friends, I urge and I request each one of you who heard me, try and go for your living will. If you have any query, my PPT is with MB Law College, my email ID is mentioned on it, and I will request the participants, any guidance needed, please feel free and get back to me. If there are any questions from your end, I would request Anushri to pass on the questions, and I hope I have not exceeded the time.
No, ma'am. So, does anyone have any questions? Yes, ma'am. We do have some inquisitive minds, so we'll have a short Q&A.
Wonderful. Oh,
I would request the participant to come in front so ma'am could see and hear you clearly.
oh yes, that would be beautiful. I will just stop sharing the screen now.
Hello. Ma'am, am I audible to you?
Yes, you are very much audible.
Okay, ma'am. Thank you so much. My question is, we all are aware of the fact that in common cause case, the passive euthanasia is recognized by the Supreme Court as on date. But my question is, because people are afraid of social dilemma, what people will say if we undergo a passive euthanasia and if we take a patient at home, what society will think about that particular case? So in this perspective, what would you suggest about the awareness, training, or is there any requirement of codification statutory framework in this regard? That is what my question is.
Okay, sir, thank you so much for your question. See, first of all, I will express something on a lighter note. We always think what will people think, and my point is, अगर हम ये सोचेंगे कि लोग क्या सोचेंगे तो हम क्या सोचेंगे? लोग क्या सोचेंगे ये लोगों को सोचने दो. Well, coming to the serious discussion, we should not bother much what people think, but as you said, it's part of society at life. To avoid this dilemma as to what people will think कि अरे भाई इन्होंने तो डिस्चार्ज ले लिया. To avoid that only, we have this concept of living will. So suppose, as I said, God forbid, if I am in that state where I am on life support system and my children take discharge because I have a living will. So there's no question of society saying anything. It's very simple. I have made a living will. It is my desire that I want to be discharged. Also, let me tell you very clearly, what today is legalized in India of passive euthanasia or removal of life support system is nothing new. This is now in black and white, but already in the society this has been happening. You may have seen in our locality most of the times the doctors say अब इनकी जिंदा रहने की कुछ ज़्यादा ये नहीं है तो आप पे डिपेंड करता है आपको डिस्चार्ज लेना आप ले सकते हो. And the doctor discharge the patient because then the doctor also said इनको घर पे आराम से जाने दीजिए. So the practice of withdrawal, discharge I would say was very common. Withdrawal of life support system now has become complicated because there are many court cases. So coming back to your point, whether we need codification, we already have. So at present, what I explained just now, the common cause case and the law, it is law in the country. We don't need a specific statute for that because that is a guideline. If the judiciary wants, they can direct the parliament to codify. But at present, it is law in the country that you can make your living will as per the living will. If it is submitted to the hospital, the relatives or the caretakers of the patient can tell the hospital this is the living will. The hospital can file. The hospital can allow. But again, there are cases where people will argue on that also. क्या नहीं ये तो झूठा लाके करा कर दिया ये तो ऐसा कुछ हमारी मम्मी ने कभी बोला ही नहीं था ये तो प्रॉपर्टी के लिए कर रहे हैं. Possible. So for that, hospital can verify, put it before the court, and then get permission to withdraw the life support system, even if there is a link. So that depends on the situation, whether it is happening amicably. But at present, this is the law in the treaty that every individual can make the living will. The living will can be executed, and with the help of the living will, life support system can be withdrawn. Society क्या बोले इससे मतलब नहीं है. You have to respect the wishes of the person. तो हमेशा ही बोलती है ना शुभम सर, अच्छा भी बोलती है बुरा भी बोलती है. So you go by the law, not by the society. Any other question, my dear?
Hello, ma'am. My question is, in case of acute euthanasia, when doctor gives the lethal drugs to the patient to die peacefully, then in how much time that patient dies, and exactly how he dies, by example, by heart failure or brain stoppage, and how much pain that patient feels in that process.
Okay. All right. So I don't know your name. I think the camera is by Shubham sir's name, and I just called Shubham sir, the previous participant. Anyways, whatever is your name, my dear. Thank you for the question. So active euthanasia is legalized only in state of Oregon, United States of America. It's a very, very critical thing to do. There can be misuse of active euthanasia. Then folks not in most of the countries. How does it happen? The dose is given to the patient. So dose is known by the doctor. Say for example, if we have morphine, morphine is normally given as a painkiller to the patients, cancer patients mostly, to reduce their pain. But if it is given overdose, and the doctors know, see I am not a medical professional, but the doctors know that if say for example 0.5 ml of mg of morphine is given, it's a dose. But if you give say 4 mg, then the patient will die. So the doctor then injects that much dose, which will kill the patient. After injecting that glucose, it goes in the body of the patient, and the patient dies. How much time, as you ask, how much pain? Now these are questions which only the pain the patient can tell, because the pain is never known to us. Yeah, and it is a painless death basically, because as soon as you inject, within few seconds the patient dies. Your question is whether the patient dies due to a cardiac arrest or a brain stroke. So naturally, this dose implies failure of heart, and the minute the heart stops, the body stops. So therefore, the response to your question is, any lethal dose which is given to the patient is targeted to stop the heart first, and that is where the person passes away. Pain cannot be quantified because, as I said, individually खुद को ही पता है कि कितना pain होता है. But since it happens very quickly, in few seconds, I assume that as that it is a painless death. So active euthanasia is only needed in very rarest of rare cases, but it is there in Oregon since 1997, and the statistics records that there are no misuses of this particular legal system, and there are a lot of check balance systems which happen before one gives activity.
Thank you, ma'am. Ma'am, my second question is, passive euthanasia can be very more painful than the active euthanasia. Then why passive euthanasia is legal and active euthanasia is illegal?
Correct question. So, passive euthanasia is legally illegal. What does passive euthanasia mean? Removal of life support system. है ना? मान लीजिए मैं ऑक्सीजन पे हूँ या वेंटिलेटर पे हूँ, मेरा किडनी फेलियर हुआ है और मैं वेंटिलेटर पे हूँ. So, मैं on ventilator for 1 month. How long can I be? So मुझे वेंटिलेटर से निकाल दिया. It is painful because you come out of the ventilator, but at the same time that can bring about your death. So we can't say that it is always very painful. You are just removing the life support system and you are allowing the person die a natural death. Why is active euthanasia illegal? Because there is more risk of active euthanasia being misused in the country, especially in a country like India, where people will always try to misuse a law. See, we have so many laws, but they are misused, don't we? We have the PNDT Act. So it is to check the abnormality of the fetus, but what have people done in India? They have checked the sex of the fetus, and we have aborted more than 20 million female fetuses in India. So high probability, in a similar parlance, this law also can be misused because active euthanasia directly gives the doctor a power. Say for example, I am in terminal illness and I request that give me active euthanasia. Now my request may come out of my emotions, and immediately the minute I say, see, many a times people say this, any terminal ill patient says, but after half an hour the patient may feel like, but in that emotional phase, if I make a request and immediately someone from my family goes and tells the doctor, active euthanasia, and the doctor gives me and I die, it can be a misuse for my property. That is the reason why if we have legalized living wills and advance directive, it can at least serve as some safeguard. But having active euthanasia may authorize doctors to kill patients on the request of their relatives, even if the patient doesn't request. Therefore, it is not really suggested to have active euthanasia legal in a country like India.
Thank you so much.
Welcome.
As we have time constraints, so I would like to one or two participants for questions.
I don't know how to do this. Do you think, ma'am, this is the right time to and favorable time to legalize active euthanasia in India and interpret Article 21 and it to regular dignity?
Well, if you ask my opinion, I will say a yes, because I have in fact drafted a bill for active euthanasia in India, but a physician-assisted active euthanasia on a similar model as we have in state of Oregon. My personal opinion is that we can do that with required safeguards. So we can't say that we will not have laws because people misuse laws, isn't it? The opinion which I gave to the previous response, I said that active euthanasia can be misused. But if you ask my personal opinion, I will say we must have active euthanasia as a physician-assisted suicide with the required safeguards. The safeguards are very important to avoid killing people for money, killing people for revengeful attitude. But we can have safeguards. Like, see, every law, we have a safeguard. Without that, a law cannot be enacted. But if the safeguards are not taken care of, or if the law is misused, then we will have people dying mercilessly. That should not be the case. We can have a 3-tier system, and that if you want, you can look on Google. My thesis is there. I have drafted an entire bill. I have in fact shared my bill with the Honorable Chief Justice of India, former Chief Justice when he was working on the terminal ill bill for patients in 2016-17. So I had even shared that at that time. So I personally feel that euthanasia should be legalized, but the safeguards should be very, very strong to avoid any misuse of the law.
Thank you so much, ma'am. You are extremely brilliant and intellectual and your expertise in this. I never guessed it. Thank you so much, ma'am.
Thank you. Thank you. So Anushri, I think this was the last question, or we have one more?
No, ma'am, we have one more last question.
Yes, please go ahead.
My name is Samiksha. Thank you so much for the session, ma'am. It was a sensitive topic put in a very inclusive way. My question to you is, there's a concept of family veto when it comes to organ transplantation cases. Do we have family vetoes in euthanasia cases as well? And if at all there exist, how can we override it, or will the advanced medical directives have an effect?
Okay. Thank you, Samiksha, for your question. So, we do not have any family vetoes as of now in euthanasia. The stage has not yet come. All we have in the living will is your agent. Okay? Now, the word agent is used for your family member who will execute your living will. Like, for example, in my living will, my daughter and my son both are my agents. So, both are major. So in that I have written that these two will execute my living will when and if I go in a terminal phase. So they are my agents. There is no other veto power which a family member has. It will be explicitly mentioned on the paper, which will be registered, notarized, and a copy of that will be available with other people. So veto doesn't come in power here. It will be only what is on the paper. Thank you. So I'm happy, Anushri, at least these many students interacted. That means some लोग सो नहीं रहे थे, सुन भी रहे थे.
Yes, ma'am. So I'd like to thank all the participants for this brainstorming Q&A. So as we move forward, I thank you, ma'am, for your profoundly insightful address. Your reflections have beautifully illuminated the nuances of this theme. And ma'am, we for sure keep it in our mind. We should add life to our days and not days to our life. We are truly grateful for your time, wisdom, and guidance you have shared with us today. This theme, as it is very complex, us to confront the delicate intersection of law, ethics, and human dignity, while also urging us to reflect on the compassionate frameworks that safeguard individual autonomy and final stages of our life. Your words have set a thoughtful and inspiring tone for this deliberation. Thank you once again, ma'am.
To MD Law College, the management trustees, principal, ma'am, all teachers, non-teaching staff, the participants, and the organizers. I express my gratitude on record. Thank you for having me here. And my apologies I could not come in person, but I shall look forward to meet you. If anybody needs any help, do approach me. Thank you everyone and God bless you. Very good.
Thank you, ma'am. With those enlightening reflections, and now gracefully proposed to the paper presentation segment, wherein our distinguished participants shall share their scholarly insights and research contributions, further enriching this discourse on today's profound theme. Each presenter will be allotted 7 minutes for the presentation. A warning bell shall be sounded at the completion of 6 minutes, followed by a final bell marking the conclusion of 7 minutes. If the participants are ready, I kindly request all the presenters to adhere strictly to the allotted time so that we may ensure smooth flow of the proceedings. So, foremost, I would like to call Prajakta Kale, and the session will be conducted online.
Hi, good morning everyone. I hope I'm audible.
Yes, ma'am, you are audible.
Are you sharing the screen? Yes, I've already shared it. Or should I do it from my end?
Ma'am, you are the co-host, so the PPT presentation is from your end.
I see.
Yes, ma'am.
Okay, I hope it is visible.
Yes, ma'am, it is.
Thank you. I'm presenting this along with my partner and co-author, Dr. Pritesh Kumar Patel. I will be presenting and both of us will be available for Q&A. Our topic is end-of-life care in pediatrics, legal and ethical perspectives. So we have had a great introduction and insight into the topic by the resource person. I won't go into nitty-gritties of the definition, etc. But I would like to stress on the core focus of our paper, which is that basically when we talk about end-of-life care, what exactly it is, what does it cover? So it covers physical, emotional, social, and spiritual support. So as to improve quality of life, and in this case for the child or young person who is suffering from life-limiting conditions, always approaching the end of life. Then it includes, managing the distress symptoms, providing respite care, support to guardians with death and bereavement. So all these factors go into what we call as end of life care. And when it comes to pediatrics groups which receive palliative care, who are they? They are usually those with some kind of life-threatening condition for which treatment is feasible but it is bound to fail. The need which has been already stressed multiple times so far. So science and technology is progressing. We are advancing now. Yesterday also there was a wonderful presentation on AI and telemedicine. So AI is progressing. We are having good leaps when it comes to advancement of medical technology, which in turn is helping to expand lifespan of the patients. Right? And because of this, we are having this dilemma of end of life, palliative care, etc. And therefore, we think that it is important for us to make a systematic, ethical, and legal analysis because so far we know that ethical dilemmas are an inherent part of end of life and palliative care scenario. Before I begin to make, I just want to quickly give an overview of what are the global practices. So in EU, for instance, there is no comprehensive law on this, and communication is something which remains a focal point. So parents are consulted because we are talking about pediatric population. Your parents are consulted at every stage. There are countries which I also just mentioned, Netherlands and Belgium, they permit euthanasia for minor or pediatric age. In UK, we have the specific act, which is Mental Capacity Act in 2005, which says that if it is in the best interest of the patient, then the medical practitioner can withdraw or withhold the life-sustaining treatment. Then in US, we have the focal point on shared decision making. So whosoever are the entities in that end of life care scenario, there's a model for shared decision making in one's care plan. When it comes to India, and I want to focus now on the ethical perspective and the focus of our paper, pediatric ethics. Now, when it comes to bioethics in general, pediatric ethics has some kind of a different notion. And the notion lies in the fact that pediatrician has kind of an independent fiduciary obligation. So fiduciary, which involves trust. So there's a relationship of a trustee and a beneficiary when it comes to pediatric populations. Medical practitioner and the child patient there's a fiduciary obligation which the pediatrician owes towards the younger child's best interest or whatever over what the parents wish for that particular child. So we have to keep this particular aspect of pediatric ethics in light when we discuss the different ethical dilemmas. And what exactly the ethical dilemma revolve around? They are mostly in the triangle of child, parent, and the doctor. And we are focusing on different ethical perspectives based on the 4 broad ethical principles, which have also been mentioned in the resource talk: autonomy, beneficence, non-maleficence, and distributive justice. So autonomy basically means your freedom to choose your life, your freedom to choose beneficences. When a physician is expected to act in the best interest non-malfeasance is doing no harm, not to impose unnecessary or unacceptable burden upon the patient, etc. And finally, distributive justice, that means treating the patient truthfully and fairly. Based on this, we are going to analyze the different ethical dilemmas. Our analysis is majorly based on the common cause judgment. So with the ethical analysis, we are deriving our analysis based on this particular judgment. So this judgment has prioritized autonomy over the notion of sacredness of life. And of course, it considers dignity as a pivotal aspect. Now, though in case of pediatric patients, the authority lies with parents or guardians, the individual whose life is in question is clearly remaining out of sight. The judgment further, so basically there is no ear to the desire of the patient when it comes to continuation of treatment or the way the dignity is disrupted in the patient. So for pediatric patients, it is just parents or guardian who decide. But the person, the pediatric patient of whose dignity is at stake, he is clearly remaining out of sight. Now, this can still be a perfect choice for neonatal patients who are very small to take in decision. But say for pediatric population, which is between 6 to 16, now this scenario really throws the doctor in an ethical lens. The judgment then further intervenes the subtle conflict between Hippocratic oath, which a medical practitioner takes, and philosopher Plato's thoughts on life and death. Now, Hippocratic oath, as we all know by now, says that it puts the doctor in moral and professional duty. There's moral and professional duty on the medical practitioner to try till the last attempt and save the life of the patient. Now, Plato, on the other hand, suggests that it is meaningless to keep surviving a patient suffering from incurable disease. As such, life which is full of suffering serves no good for the soul, and ultimately it is devoid of reason and virtue. And therefore, if you withdraw life-sustaining treatment, it seems unethical from the point of view of Hippocratic oath, but seen from Plato's lens, this action may look morally sound in certain critical instances. Now, what is the problem here? So this judgment elaborates on three facets, that is social morality, medical ethics, and the interest of the states. And this dilemma is placed against the constitutional setting. So if the doctor adheres to the Hippocratic oath, he has fear of criminal negligence or say culpability, and if he follows the opposite, he goes against negligence. So common cause in a way sides with the Platonian viewpoint.
Sorry,
Clearly
you
states.
pass, but your time is up, so can we sum up and wrap it up
I'm
in
just
1 minute?
concluding. I'm
Yes.
just concluding. So the problem here is the ethical dilemma between this Hippocratic oath and Platonic oath. So in either side, it is the medical practitioner who comes and fix. And when it comes to legal perspectives, I'll just conclude in half a minute. A lot has been stressed on the dignity. So end of life care is all about right to die, to dying in a meaningful way. So there has to be dignity which is inherent in that entire process. But dignity is often not an inherent right, it a birthright for children. We have explored other rights for children when it comes to their hazardous employment, etc. But unfortunately, this aspect of dignity is not explored for children. This is what we intend to do from our research. When we look at the 241st Law Commission report, it suggests that incompetent patients, may have right to take decisions and express their desires. But the gray area here is not about children. Can they take any decisions? Now there are also multiple guidelines at the 2023 Supreme Court guidelines which throws more light on living wills. But still there are a lot of procedural complexities. In even Aruna Sharma's cases, it expounds the doctrine of parents patria, where judiciary as a representative of sovereign would behave the same manner as a parent would do. Now this has a problem in Indian context because there is a lot of risk of misuse. We have unfortunate tendency of female infanticide, and there are other social economic factors. Therefore, keeping judiciary out of sight may not be so feasible from the Indian perspectives. And it often is seen that Indian physicians they prefer patients to go lama, that means left against medical advice. And even the caretakers in India want patients to take their last breath, maybe in their home, native place, or holy places, such as conflicts of rivers, etc. So there are these legal ethical perspectives, and the intention of this research through qualitative doctrinal analysis is to find a middle way. So, to measure for society can be found in how it treats its most vulnerable members, is what Kartiji said. So we, through our research, intend to see whether there is a possibility of a dedicated law from the Parliament, and also what steps should be taken, maybe in terms of training of medical practitioners in ethics, institutionalizing ethical committees, and if at all a comprehensive framework is at all possible. So I want to conclude and I welcome any other questions are there. Thank you so much.
Do we have any questions? Okay, ma'am, we do not have any questions. Thank you for your efforts. So, next I would invite Mr. Nikhil Sathe, and the presentation will be on the online mode.
Am I audible?
Yes, you are audible, sir.
Okay. Let me share my. The PPT is visible.
No, sir, the PPT is not visible. Yes, sir, now it is visible.
Thank you.
Sir, you can proceed.
Okay, thank you. So, this is Nikhil Sathe, student of Central University of Karnataka, co-author of this paper, along with and behalf of other co-author, Dr. Anand Chinkle, Associate Professor, Central University of Karnataka. I will be presenting this paper titled Resolving the Medico-Legal Dilemma of Future by Integrating the Defined Principles and the Living Will of Perspective. So, the famous metaphysical poet John Donne says, I quote, "One short sleep past, we may utter eternally, and death shall be no more. Death you shall die." So, the first thing first, I'll start with the introduction to what this paper contains. So, how ignition and ignition are shaping the medical jurisprudence problem. Then, person anything in paper, that is the conceptual understanding of ignition. How the practice of ignition can be governed politically with interpretation of living will along with the defined principle, then the constitutional right to life includes right to die, and the interpretation given by the various courts in the worldwide. And the end, the paper attempts to draw in understanding of this as a right to end suffering and the legislative backing into if staying there. So the first aspect of this paper is like ignition conceptual understanding. So you can see the graphical depiction of patient that the person or the patient is in persistent vegetative state getting the life-sustaining treatment. So what actually it means by this is ignition is the act of asking the death of patient to relieve from suffering, and that the suffering may be caused by either by accident or by any diseases like AIDS, hepatitis B, or schizophrenia or so on. It is visible?
No, sir, you have stopped sharing the slides. Yes, sir, now it is visible.
So what are the issues so involved in this practice of euthanasia? So there are moral and legal issues like whether the guardians or the parents can kill their when they are in not a position to give consent, and the legal issues whether the patient taking a patient's life without his consent, whether it amounts to homicide or not. Then the other it is very physically, mentally, financially draining for the family member to bear the such procedure. Another issue is legal aspect, that the legal cell in which the euthanasia form is not uniform. So there are various interpretations given by various courts or legislative commentaries on the same. Then another aspect, living will and defined principle. What we are proposing, this practice of euthanasia can be governed positively if we inculcate living will or defined principle, either provided by the judiciary or the legislative manner. So the living will is a legal document by which the decision making is preferences. When he is a sound mind and sound body, if in case we reach in such position that he is not he is not in a, he is suffering from any incurable disease. So he can he will dictate what kind of process or what kind of mode of procedure when he is in vegetative state. And then living will comes into the effect when he will reach in such position or the persistent vegetative state. So what is the legal framework for euthanasia? Different countries having different interpretations. Countries like Belgium, Canada made this practice of euthanasia as illegal, but however in the there are countries like USA. USA has around 50 states. Even in that 50 states there is no uniform consensus about this practice of euthanasia. Like states like Washington, Montana, Vermont, they have made this physician-assisted suicide. Here, physician-assisted suicide takes the color of active euthanasia, and they made it legal. But however, so far India is concerned, we don't have any kind of formalized statute. However, so far, but we have guidelines given by the judiciary in the common cause as well as the Arunachal Prदेश. So what is judicial approach to the euthanasia? That another aspect of our paper. So the Supreme Court of Netherlands, one of its judgment observed that physician can perform active euthanasia with one person who are suffering with the severe dementia. However, they have to complex procedure or necessary procedure. While the case, Supreme Court of United States checked that the right to physician-assisted suicide is the active euthanasia and made distinction against the passive euthanasia or withdrawal of passive treatment. So, what is the judicial approach to euthanasia, in particular in Indian context? The judicial awakening on this subject goes back to the Maruti Dubal versus State of Maharashtra. However, the person or actually in this case was the police constable. He suffered a very major accident, and after he started suffering with schizophrenia, he tried to kill himself. So in that case, Mumbai High Court said that right to life includes right to die, and then another P. Rajina versus Union of India upheld the same ruling. But however, Ganpur case overruled this judgment and said that the right to life does not include right to die, and this propounded that if any change wants, if the society wants any change, it is a function of legislature who will bring that change through a law. Then will the Arunachal Prदेश case, we didn't have any kind of specific rule or procedure regarding the euthanasia in formalized manner. Then Law Commission of India issued August 12th case. Law Commission of India issued 41st report, also for anything of standard, any kind of backing. So these guidelines are nothing but these guidelines are a kind of statements propounded by judiciary during their judgments, like Arunachal Prदेश and Supreme Court of Netherlands. So another aspect of our paper is modern medical advancement. Earlier, the techniques like CT scan or the PEG used to be used. They are still in our use, they are still continuing. But however, nowadays there are two techniques has been employed like coma recovery skill device, CRS, and another like functional MRI and electron tomography. These are like concept who measure the person's blood flow when the patient is in persistent vegetative state. This instrument calculates blood flow or metabolic activity in the brain as well as the tissues or other nuances of that person's body. So what at the end we were recommending to this paper, despite the legal sequence, suppose a person had given his preferences or his a kind of living will. In some case, it may not be even be. In case he has future perspective of recovery or future prospects of recovery. This is another patient like I have not been from the suspect.
Sorry to interrupt, sir, but your time is up. So can we just conclude in 1 minute?
At the end, what we are suggesting through this paper. What we are suggesting to this paper, that 196 Law Commission report given a medically terminal patient protection of patients and the practitioners, that bill can be enacted with the essential guidelines if they are to propounded in Arunachal Prदेश as well as the medical societies who are working for the physical and protection of legal and ethical aspects of the patient. In particularly, there is a procedure to proceed with the patient. Thank you.
Thank you, sir. So moving forward, I humbly request the remaining participants to please adhere with the timings, and there will be no Q&A sessions as we have a time constraint. So next, I would like to call Mr. Mihir Khairnar for his presentation.
Hello. Very good afternoon, everyone. Imagine you are sitting aside someone who you deeply love. The hospital room is quiet except for steady beeping of machines. Tubes surround their fragile body. Days have turned into weeks, weeks into months. The doctor have done everything medicine can do or offer. But every intervention only prolongs suffering. One day, they whisper to you, I don't want this anymore. But what happens when tomorrow they can no longer speak? Who decides? The family, the doctor, the court, or the constitution? This is where law meets humanity. So today, we ask difficult but necessary question. If we respect autonomy in life, why do we hesitate to respect it at the end of life? Our research title, Living Wills, Jurisprudence of Letting Go by me and Mihir, examines the gap and argues recognition of living wills without legislation leaves dignity incomplete. So these are 4 chapters of our research paper. Let's start with introduction. End of life decision raises a serious constitutional, legal and ethical questions in India because choosing life is easy for the law, but choosing how one should die is not. The law clearly protects the right to live, but regulating the right to die is much more complex. Most discussion on existing literature focuses on passive euthanasia and living wills have received less attention. So, from our paper, we argue that India needs a proper statutory framework for living wills. Our next chapter is Right to Life under Article 21. Article 21 is all about right to life, but Article 21 is not only about right to live life, it is about dignified human existence. So, Supreme Court has expanded the right to include dignity, privacy and personal autonomy. The court has recognized passive euthanasia under strict conditions, but active euthanasia is still illegal in India. Advance directives and living wills allow individuals to express their medical wishes in case of future incapacity. But still, this principle shows that right to die with dignity is now constitutionally recognized but carefully regulated. Advance directives are divided into 2 parts or 2 types. Healthcare power of attorney and another one is living wills. Healthcare power of attorney focuses on who will decide for you, and living wills focuses on what medical treatment you want. It is express wishes about medical treatments.
The third part of our research was about diving into the Indian scenario regarding living wills. So during our research, we found that there is no comprehensive law on advance directives or living wills. But 2 legislations deserve a honorable mention here. The Mental Health Care Act of 2017 talks about advanced directives, but only in the context of mental illnesses. Secondly, the National Medical Commission Regulations 2023 also mention about advanced directives, but only in cases of risky surgeries. The Honorable Supreme Court, in cases of Aruna Shanbag and Common Cause, have recognized the validity of advanced directives, including living wills. But without a proper legislation, implementation of these guidelines faces a lot of challenge. During our research, we have also conducted an extensive comparative analysis with the country of USA, and I would like to shed some light on how the US got these things right. So firstly, they enacted a federal legislation, that is the Patient Self-Determination Act of 1990, which has paved the way for all the states, or certain states, for enacting a specialized law that talks about advanced directives. Firstly, it was California via the California Probate Code of Division 4.7. Secondly, it was Texas Advanced Directive Act, Chapter 166. Thirdly, it was New York Public Health Law, Article 29C, just to name a few. So, arriving at suggestions from our research, firstly, we would like to see if there is, if we can have some mandatory disclosure by medical practitioners to the patient as a part of their professional ethics. We would also like to see a clear and comprehensive legislation on advanced directives, which includes the standardized national format so that there is no ambiguity. We would also like to see a central data registry which records all the information of advanced directives and is accessible for all the healthcare professionals. We sometimes see that the patient's status are also displayed in the hospitals. We would like to see that information on advanced directives, including living wills, to be included in it. In the end, I would like to conclude by saying that this discourse is not about choosing death. This is not about ending life. It is about dignity. It is about respecting autonomy when life is ending. Because if Article 21 guarantees dignity, it should do so until our very last breath. Protected not just by judgments, but by clear and comprehensive as well as compassionate legislation. Thank you.
Indeed, an amazing presentation, me, Karnik and Anuja. Now I would like to call upon Ms. Aditi Ankush and Mr. Jay Gavde for their presentation.
A very warm morning to all the distinguished members, esteemed medical and legal scholars, and all my fellow researchers. I, Aditi Ankush, with my co-author Jay Gavde, will be presenting our paper titled as Passive Euthanasia and Right to Dignified Life, where we re-examined the ethical and legal boundaries of end-of-life phenomena. Now, because of time constraint, I will be presenting the whole paper, but the efforts are from both the sides. It is to be noted by all of you. Before moving forward, I would like to confirm that our inquiry is not merely about whether one should choose death or whether one should choose life. Rather, our inquiry is about the constitutional dignity, whether it permits the refusal of technologically prolonged life. Now, our core principle or our core proposition is threefold. The first analysis or first thesis is that whether Article 21, after Maneka Gandhi's interpretation, has decisively constitutionalized the dignity and decisional autonomy of an individual. Secondly, that the passive euthanasia, it is not an exception to right to life. Rather, it is an extension of the dignified life. And thirdly, that while judicial recognition in India is doctrinally sound in this topic, but as my before co-authors also mentioned, that India's reliance on judge-made procedural architecture
leaves some structural vulnerabilities which are unaddressed in India. Now the very fundamental jurisprudential tension in this phenomena is not life versus death. It is between sanctity of life doctrine, which is very much rooted in moral absolutism, and versus the autonomy-based dignity doctrine, which is grounded in liberal constitutionalism, where medical intervention reduces the existence of biological persistence, which is very devoid of an cognitive agency. The very question in this phenomenon becomes, is the state actually preserving the life or compelling an individual to continue mere corporal functions? Now that distinction is constitutionally decisive. We all know that death nowadays has migrated from a domestical or natural sphere to a clinical approach. Now, may it be about mechanical ventilation, extracorporeal life support, etc., which we are discussing from yesterday. But this procedure which we are talking about is known as medical futility, where medical intervention no longer restores health or quality of life, but it is merely a preservance of a permanent unconsciousness of a person. In such context, the law must determine, In such context, the law must determine whether continued intervention constitutes a care for an individual or it is an coercion. Now, if we talk about the methodological framework under this paper, the guiding inquiry or hypothesis, which we call it as, remains a very fundamental, that is, does Article 21 protect right to refuse an invasive life-sustaining treatment even where that refusal will result in death of a person? Before moving forward, one should know what passive euthanasia is and how it is differentiated from active euthanasia. Now, active euthanasia, as we discussed, is completely illegal in India, but passive euthanasia involves withdrawal or withholding of life-sustaining treatment. In such cases, where the underlying pathology or illness is irreversible in nature or recovery is medically impossible. Third, the continued medical intervention lacks the therapeutic benefits or quality of life. Now, legally it is classified as allowing the natural process to die, and it is not mentioned as causing death. So as a law student, we must know it doesn't fall under any definitions in criminal laws. Now, if we talk about operational mechanisms under passive euthanasia, it involves withdrawal of ventilatory support, cessation of dialysis, then we all know about DNR directives which are used for CPR, and the terminal sedation under doctrine of double effect, wherein passive euthanasia, the inducement of unconsciousness is given to a patient to reduce his pain. Now, all this comes under a very ethical structure, again, the intersection of ethics and law, where we come forward with four fundamentals. First one is autonomy, which is to be preserved. Autonomy is offered decisional sovereignty over oneself's body. The second aspect is beneficence. It is related to obligation of a next friend or an agent in case of euthanasia. Third one is non-maleficence, which is duty to avoid harm. And last one is justice, which is fair distribution of medical resources. Now, as we all know, and I think I shouldn't discuss this in detail, but Article 21 includes privacy, bodily integrity, decisional autonomy. So now, for such now in India, dignity is no longer rhetorical. It is very much enforceable. In that context, we must know a judicial trajectory which followed in India for passive euthanasia to become legal. First one is P. Rathiram versus Union of India, which briefly recognized right to die. But just after that, Gyan Ghosh case came, and it was right to die was completely rejected as a part of Article 21. But the very fundamental case which we are discussing from yesterday morning, which is Aruna Shanbhag versus Union of India, where passive euthanasia was granted under High Court supervision. But just give me. But I think the very fundamental in this case is of Common Cause versus Union of India's case, and further the 2023 modifications which rationalized the process of passive euthanasia. I think I should directly come to advanced directives which was given in 2023. These advanced directives operationalize prospective autonomy, They preserve the decisional authority even after incapacity, and we are very much in agreement to what these advance directives given by courts are useful in living wills or passive euthanasia. However, absence of statutory registry and uniform hospital compliance mechanism renders the inapplication very much even in country like India. Very much uneven in country like India. So now autonomy without accessibility becomes extremely symbolic, which we are not looking forward to. Now if we talk about comparative reflections made by countries like Netherlands, Belgium, Canada, Switzerland or certain states of US also, they rely on legislative frameworks while we, country like India, our model remains extremely judicial micromanagement. I will conclude in 2 minutes. Okay. I'll directly go to suggestions. We have suggested 5 reforms which to be discussed. First one is comparative, comprehensive and structured end-of-life care legislation which should be enacted in India, which will give statutory clarity on procedure, safeguards and immunity, especially for cases where living will is upset or there exists a grey area may be for the consent for or for minors. Second suggestion is National Digital Registry for Advanced Directives. It will ensure accessibility and authenticity of living wills. Third one is mandatory palliative care consultation and awareness program in India, because withdrawal decisions or euthanasia decisions must follow informed exploration of all comfort care alternatives before going to end of life decision. Fourth one is uniform medical board protocols for transparent documentation and review timelines. And last one is good faith immunity clause which will protect doctors acting within procedural safeguards. And with that we conclude our presentation. I thank all the members and my fellow researchers for kind listening. Thank you so much.
Thank you, Aditi and Jay, for a powerful deliberation. As we come to the conclusion of this session, I would like to call upon Dr. S.S. Bharatiya ma'am to give an insightful conclusion recap of this session. Over to you, ma'am.
Thank you, Aditi. Before beginning this concluding remark, let me welcome respected Joshi sir, former judge of Bombay High Court. Sir, on behalf of college participants, I formally welcome you in this gathering. Now regarding today's session, it was a very wonderful start by Dr. Sharmila Bhuge madam. She very lucidly dealt with the topic of end-of-life choices, delimiting the complexities of euthanasia and living wills. In her discourse, while referring to the various present live examples, she made us, all of us, understand the complexities of this living will, euthanasia, active and passive euthanasia, and n number of points she discussed. I am sure that after listening her discourse, many students amongst you, including me, we are inclined to have our living wills. Now, after her discourse, in this session, we had total 4 presentations, 2 in the online mode and 2 offline mode. When we go with online presentations, first presentation was given by Ms. Prajakta Kale, wherein she dealt with end-of-life care in pediatrics, legal and ethical perspectives, in which her research paper was focused on the pediatric groups, particularly regarding palliative care of the minors. She did very proper legal and ethical analysis of the concerned topic. Secondly, we heard Mr. Nikhil Sathe, and his topic was resolving the medico-legal dilemma of euthanasia by integrating the defined principles and living wills perspective. So in his presentation, he dealt with various issues involved in euthanasia. He also discussed legal frameworks regarding euthanasia around the globe. He referred various case laws, decisions of the Honorable High Court and the Supreme Court, and very nicely he presented his paper. Thirdly, on offline mode, we listened to Mir Karnik and Miss Anuja on living wills, the jurisprudence of letting go, wherein they dealt with right to life under Article 21, then various types of advance directives. They compare India with other countries and they did very comprehensive analysis while giving some concrete solutions also. And lastly, just now we heard Miss Aditi and Jay upon the topic passive euthanasia and the right to dignified life, re-examining ethical and legal boundaries of end-of-life autonomy, wherein they did constitutional inquiry, jurisprudential aspect they discussed. Then, and in their research paper, even they gave very concrete suggestions that there is need to have the legislation, and in the absence of, in case living will is not there, or in case of minors, we need to have proper framework along with the various implementing authorities. So here, definitely we appreciate the efforts put in by all the researchers. They did quite good research and even they did the proper presentation. Thank you so much.
As we move forward to the conclusion, I deeply appreciate the valuable research contributions of all our presenters. The perspectives shared today have underscored the profound significance of our theme, end-of-life choices, navigating the complexity of euthanasia and living wills, reminding us of the delicate balance between law, ethics, human dignity. Now I would give a vote of thanks on the behalf of MLNGE Society, Manikchand Bahare Law College. Formally, I would like to thank Honorable Shri Justice Ambadas Joshi sir for his graceful presence. Nextly, my sincere gratitude to Dr. Sharmila Gugge ma'am for her enlightening and thought-provoking address, which has enriched our understanding of this sensitive subject. Next, heartfelt thanks to Dr. S.S. Barathe ma'am for graciously introducing the theme and setting the intellectual tone for this session. I extend my appreciation to MLNGE Society Manikchand Pahade Law College for the unwavering support and to the Avishkar Research Club for their dedicated efforts in organizing this session. Finally, my warmest thanks to all the presenters and participants whose engagement and contribution has made this deliberation truly meaningful. With gratitude and reverence on the behalf of organizing committee, we formally conclude session 4. Thank you for your presence.
Good afternoon to one and all present here. Honorable Justice,
Good afternoon to one and all present here. Honorable Justice Shri Ambadas Joshi sir, dignitaries on the dais, respected faculty members, fellow participants and student friends. I, Omisha Priya, a student of BLLB 3rd year, on behalf of MLG Society's Manikchand Pahade Law College, welcome you all in the 5th technical session of 2 days National Conference on Life, Law and Ethics, navigating the complexities of organ transplantation, palliative care and right to dignified life. Our 5th session basically focuses on the theme that dignity of life, medico-legal cases, and Indian judicial response. Now to introduce this theme of the session, may I request our teacher coordinator, Professor Dr. Pratibha Girbani ma'am, to share her valuable insight.
Thank you, Misha. Resource person of this technical session, Dr. Santosh Kakre sir. Honorable Justice Shri Ambadas Joshi sir, who has specially come for this particular technical sessions, all the respected dignitaries and participant students. I am standing before you to give brief introduction about this technical session. Before introducing this technical session, I welcome you all. The theme of this session is dignity of life, medico-legal cases, and Indian judicial response. In the beginning, I would like to mention once what Dr. Babasaheb Ambedkar has said. Babasaheb Ambedkar once has said, the Constitution is not mere law's document, it is a vehicle of life. And according to me, at the heart of that vehicle lies Article 21. Article 21 which guarantees right to life. And the scope of Article 21 has been expanded in many judicial pronouncements. As far as Article 21 is concerned, this article on many occasions Supreme Court of India has interpreted this right to mean not just living but living with dignity. As far as medico-legal cases are concerned, today these medico-legal cases are steadily increasing in India. Thousands of complaints relating to medical negligence are filed every year before consumer commissions across India. In addition to that, hospitals they routinely handle medico-legal cases which may involve situations like trauma, consent of the patient, and emergency surgeries or emergency decisions which might have to be taken, especially in case of road accidents. And this is how frequently this law and medicine, they intersect. In this background, judicial response becomes very crucial. And Indian judiciary, it has played a very transformative role in shaping the dignity, which is the center of medical jurisprudence, we can say. In this background, the cases like Aruna Shanbag versus Union of India, case like Common Cause versus Union of India, in which Supreme Court has recognized that dignity extends even to the final stage of life. These important decisions show that court tries to maintain the balance between protecting life and ensuring that life is lived with dignity and reasonable quality. In medico-legal cases, courts do not merely interpret the statute, but they safeguard human dignity in the moments of vulnerability. When we talk about human dignity, like from yesterday, since the inauguration of this seminar, every speaker is highlighting on the term of human dignity and different approaches to human dignity we are trying to understand from yesterday. Now this session definitely, which is having main theme of human dignity, this session is very important and it will help us to understand how Indian courts have shaped the rights of patients, duties of doctors, and evolving standard of care. And actually we are very honored today to have with us a resource person of today's session, Dr. Santosh Kakre sir, who has actually served as former president of State Consumer Redressal Commission, Mumbai. And he has presided over the matters that are directly affecting the lives and rights of citizens. And his perspective today, I am quite sure that his perspective today is going to give us very proper insight, because his practical experiences also he will be sharing with us, and I hope that this session definitely will be very much enriching to us. With this, I will stop with my introduction and thanks the organizers for giving me this opportunity. Thank you.
Thank you so much, ma'am, for sharing your insights with us. Now moving to the most important segment of which we are meeting, I feel like it is my honor to introduce our esteemed resource person of today's program, Dr. Shri Santosh Kakre sir, former in charge President of State Consumer Dispute Redressal Commission of Mumbai. So it is a matter of great honor and privilege for us to welcome Dr. Shri Santosh Kakre sir, a distinguished academician, medico-legal expert, jurist and healthcare leader who has graciously agreed to be the resource person for our two-day national conference. Sir possesses a rare and remarkable combination of qualification in medicine, law and management. He holds a degree of MBBS, MS Surgery, DNB, that is Diploma in National Board of Surgery, Diploma in Orthopedics, along with advanced legal qualification including LLB, LLM, PhD in law, and in addition, he has earned an MBA in hospital management and executive MBA in finance, making his profile truly interdisciplinary. He has served with distinction as a non-judicial member in charge president of Maharashtra State Consumer Dispute Redressal Commission Mumbai, completing a full tenure of 5 years from 2017 to 22. Dr. Kakre sir is also a former professor of law and management at Maharashtra National Law University Aurangabad, where he held the responsibility of HOD and Director of Executive MBA program. His PhD research on medical negligence under Consumer Protection Act 1986 involving analysis of 350 landmark cases is widely acknowledged for its depth policy relevance. In addition to this, at international level also, he is an international fellow of American College of Legal Medicine, USA, and has been a recipient of prestigious scholarship from American College of Healthcare Executive and Cleveland Clinic, USA. We are truly privileged to have such an eminent personality with us today, and please join me in extending a warm and respectful welcome to Dr. Shri Santosh Kakre sir. Now, the moment we are waiting for, I most humbly and respectfully invite sir to kindly deliver his expert address. So the session is yours now. Yes, sir, you are.
So I am actually deeply honored by the presence of Honorable Mrs. Shri to come in particular in the session, and even thankful to you, sir. At the outset, let me thank the organizers of this national conference, Manichan Mahade Law College, the Board of Trustees of this particular society, the principal madam, Dr. Napapale, the faculty, and the students and the participants of this particular 2 days of national conference. Actually, I was supposed to be physically there for the interaction, for this interaction session, but for certain reasons, it was not possible for me to come out to Somalia, and that's the reason why I am leading this particular session from Pune. When I have gone through the whole session schedule, I found that there is a relaxed speaker. So starting from the inauguration till now today, last day when the session began, all 6 technical sessions, and at the same time, all the paper presentations were pretty good. So the papers.
Sorry to interrupt you, sir, but may I request you to kindly bring your mic close to you? Your voice is quite low.
have an impact in society. Now moving ahead, so one time I was there in the same hall, I had an opportunity to research the schools, the certain concepts of the medical engineering. Now I'm thankful to the one who has introduced me. After practicing at the children of certain for almost 20 years, and working at the top management in various hospitals. After completion of my PhD in law, I got an opportunity to become a non-judicial member. Of course, preside over the judicial proceedings of the state convention. And for some time, I was in charge president of the state commission, so that has given me a wide range of experience. So I was informed. I analyzed 250 cases and judgments while performing or while doing my PhD in law, and that gave me some insight definitely to deal with and even decide the matters of living. Being a doctor, obviously, I got certain more insight while deciding and deciding the matters of living. Now, let me share with you the presentation, and I'm sure the topic at 1:30 was a little time schedule, which has been set for this particular program. So I'm sharing my presentation right now. I hope that is visible to all of you.
Yes, sir, it is.
So screen is visible to all? Is that what is on?
Yes, sir.
Right. My
Yes, sir.
yes, and I consider this that this is seen by all. So for this conference on LifeLaw and ethics organized by the Law College, and I'm sure there are many conferences of future and the topic which I'm now going to discuss with you is relatively new. Since yesterday, as it was mentioned, you have been listening to various parameters which development of the life. And the core concept of the pedagogical cases and the Indian judicial response is the basic theme actually of my PhD. So this is to go and I have appeared the topic and how the overall conceptual evolution of the medical negligence and what are the judicial response to these concepts. So this was the main matter of interest for me. And as I always say that in the doctor, I always used to actually think when the advocates do not know anything about anything, when the sitting judges on the benches, they do not know the medicine. Patient doesn't know medicine and law, then how the matters of negligence are being decided and the orders are being passed. Fortunately, I got this opportunity, and then I got to know that there are certain principles which actually the sections of the various laws, it is very clear now, the Convention of Which Act 1986, and now it's a new version, Convention of Which Act of 1990, has given, and obviously the guidelines, technical guidelines that set by various judgments, they have been the guidelines for deciding these kinds of cases. Moving ahead, I hope the slide has changed.
Yes, sir.
Please confirm.
Yes, sir, yes.
Thank you. So now, in particular legal business, one is the medical aspect, and the second one is the legal aspect. The dimensions, the dimensions are the legal ones, while the conceptual understanding of legal aspects of emergency as well as the particular types of cases which are labeled as medical cases, that one is service. And that's the reason whenever serious patients because of accidents or because of diseases when they are admitted now in emergency room is ER. These are the cases or the cases of deaths. So cases involving accidents, new patients who are not dead or got to the emergency rooms. When we are taking then various kinds of you can say poisoning and certain cases they are termed as medical cases. If we are going to see the details of that, and of course, we intend to discuss some of the judgment by Honorable Supreme Court of India, and we all know that the landmark cases are always taken from the Supreme Court of India, and you might remember the principle of doctrine of stare decisions. That means the principles or the issues of these cases are binding on all the courts of India, so that we are aware of the lawsuits. So what is the particular? The cases in which legal use rather than copying legal language, I will talk in the language that is understood by the layman and the law as such. Now, whenever cases which involve injury where the circumstances demand supervision by law, law enforcement authority are very good. Now, doctors' duty to report. Doctors have reported duty to report in such case. The physician has the legal obligation to register, report, and cooperate with these are the cases which are known as legal. Now, here, the way medical report is this person first, patient's first. Now, we all are aware that the patient has rights and various cases that actually clearly on the application of the patient to the medical patient has actually clearly that the rights of consumers are taken or they are the rights of patient as well. Now, the rights on the second. Talking about the doctor's freedom, so being an general doctor, I work on both and saving patients' lives. The patients, either patients will be to the hospitals, so the hospitals wherever I work. Now, the doctors who receive the patients, they have this responsibility to go to the needs of the doctor, right? With various judgments, I'm going to mention two judgments later on. Within the treatment part, which is quite Union of India. In this judgment, the principle that the doctor is issuing treat the patient, right, to save the patient's life, and then all whatever the process or the procedures for according to the legal basis has been followed. So duty to report, as we have already discussed in section 29 of the criminal procedure code, or basically the same number that section DNS. So DNSs are that mandate. The count police for police information after initiating night civil. So not before. And particulars of documentation forms. Of course, you all are aware that the documentation always forms the main key of taking care of the patient in case of medical big cases. So what are the types of medical cases? So injury that suggests an offense that has been discussed. Now, so this is one fact. The sexual and reproductive assault cases. So criminal abortion, requiring family and evidence of preservation. So these are the medical legal. Unnatural deaths. Whenever the reason is not notified, so death in the accident, fire engine, taking shock, materials, and many times suspected suicide. So both few of the mentioned that now is not a criminal liability of that person who attempts suicide. Still, becomes a medical industry and use the vision. So this is quite important aspect. Now moving ahead, building the confidence between the two is medicine and law. So emergency ward information, say that we part of the I'm sure group of must have the rules and the validity where serious issues are not in the future. So here, the decision that doctor of the those critical moments that shape love, rather in one of my research activity, I actually after collecting the data that when the patients are critical patients are treated well in the emergency room. And certain patients require less or there the less complications are there and even uses the medication. So this is quite important. The first critical moment are very important where the medicine and law is concerned with the topic or beginning of where there is a sign. So initially, in the judicial landscape, now I actually analyzed my cases of national and under 51 different parameters where the judicial response was initially studied and the final outcome of that I think now 1986 to 40 years, the Indian courts have created infinity populated what is the meaning of this? The meaning is that this particular concept is important. So, as and when cases are being ruled by India and judgment and orders are passed, various principles of the patient's care, of course, in relations of government, patient can decide which treatment to be undergone and whether to accept it or not. So this is the concept of dignity. Now dignity of life starts with it is not only dignity of life, dignity of death also is there, which was discussed by two of these speakers in the paper. So here, the protection of the patient's right is one, as well as the doctor's response. So there should be a balance between the judiciary, as we are knowing that the judicial activity is the core of principle which our judiciary or which our legal system holds, and this judicial activity, what does actually do? That wherever there is a need of immediate compliance, means whatever the previous sections meaning is not clear for the judicial decisions, they is concept clear and that on the law. So you consider that the judgment law is the force of this Indian judicial landscape on medical India. This is actually part of research. Now, what is the definition of treatment? You know that doctor or the medical professional who is only the patient. Of course, there are landmark judgments which say that when a patient consults a doctor, then he starts. Now, if there is a breach of this duty and there, as a result, there loss to the patient, harm to the patient, injury to the patient, that is known as illegal defense, but there must be a link between the breach of duty and so that we are knowing about the concept of. So what are the ways that she Jacob Matthew versus State of Punjab 2005. I'm sure you must have heard about the law, wisdom judgment. But here, every now and then, human mind assume or the criminal prosecution of a legal professional cannot be done. And in this case,
Excuse me, sir.
guidelines of the medical professionals can be dealt with or
Sir, sorry to interrupt you once again.
followed by the only require Secondly, not difficult. Of course, I'm not going into the details of the impact of people. They are very much fascinating to hear and to listen. In short, in marketing case, the patient was
Excuse me, sir. Sorry to interrupt you once again, but just can you please bring your mic closer to you? Like the voice is not clear and it is just we are unable to hear what you are saying. Voice is too low. It's like you are audible, but the voice is low.
now I'm audible.
Yes, sir. Yes.
So sorry about that. So the landmark judgments we were talking about, the Jacob Matthews case versus State of Punjab, in this case, the on-duty doctor failed to attend a terminally ill cancer patient and there was no oxygen available. So what happened was the son of that particular patient filed an FIR and the whole criminal proceeding actually took place. But then finally the Supreme Court said that the circumstances are to be considered here, to be taken into consideration. And every now and then for the matters, such matters, the criminal proceedings cannot be initiated. And hence, the guidelines were actually given by the Now, 2009, Martin D'Souza versus Communist I was talking about this. In this case, the kidney failure patient whose urea and PR, he was given nephrotoxic, means the drug which was toxic to the kidney, that is injection, amikacin was given. But then it was proved that it was based on evidence, that means the culture and sensitivity of the injury was done, and this was the only drug which was administered. Fortunately, the patient never died, but he responded and though it took a long time, the patient's life was saved. So in this case, the Honorable Supreme Court has said that the circumstances are need to be actually considered, and when this is evidence-based, one cannot actually go for a criminal proceedings against doctors. So these two judgments, they actually help the medical professionals who have their rights against positively heard. Kulsum Sharma versus Batra Hospital, 2009, this again has emphasized the institutional accountability. That means the hospitals are responsible and liable in case of the medical negligence matters. Now here, Honorable Supreme Court has given 11-point guidelines. So these three are quite important landmark judgments. So though while shaping this particular concept, these judgments have played very important roles. Jacob Matthews judgment, as I was talking about, that the prosecution of doctors for negligence, there is a process which is required. So the process means the one has to actually obtain an expert opinion, and if at all the expert opinion says that there is a gross negligence, then the medical professionals are being prosecuted. But still, the gross negligence concept is not really the law, and hence there exists a gap. So, as we know that there is evolution of these concepts. So this is Jacob Matthews' case, and then we were talking about the another case which I have already spoken about, the Martin D'Souza and Kusu Sharma. Here I will just take 2 minutes actually to just inform you about some other 2 judgments of landmark cases. So one which is quite famous, we know that Chauhan Katara versus India, 1989. So here, the dignity of life was and now by this time everybody knows that the Article 21. So right to life, as well as this is being discussed that whether there is the right to death also. So this of course we have heard so many concepts and parameters of it. So here the court ruled in this case that it is a professional obligation for a professional to treat a serious patient. So this is Parmanandi Katara versus Union of India. Then another case, 1996, Pashchim Banga case, Majdoor Samiti versus you might remember last time also I discussed this about that a young individual went from a train. He was taken to various medical college hospitals in Kolkata, and he paid the Majdoor actually. Since there was no place for a patient, hospitals were full. He was tossed around. Though he did not die, but finally, next day, afternoon, he was admitted in a private hospital, where fortunately his brain scan was just prima and there was no threat to his life. But still, similar kind of situation should not arise. This PI, which was required Supreme Court of India, has actually stressed the same concept that now the medical professionals from India, maybe private hospitals, maybe private medical professionals, or the government hospitals also, they need to treat the patient, and of course various processes were actually involved, and the patients must be treated, number one. Number two, must be stabilized and settled in the medical language, and then if at all there is a condition of treating such patients, the patient should be transferred to another hospital where the provision is there. But it is the responsibility, primary responsibility of the medical professional who saves the patient. These are the 2 important judgments which give the concept of dignity of life. Then we know that there was one more judgment in 1995, Indian Medical Association versus DignifiedLife. So by this judgment, the Consumer Protection Act 1986 was applied to the medical profession. Of course, it's very much interesting to read this particular judgment. The Supreme Court has beautifully come out with the concepts of consumer rights, patient rights, and who should be a consumer, who should be receiving the treatment as such. So, because this is quite important. So, the negligence concept was actually taken into account in this particular thing, and since that particular application of this act to the medical profession, number of cases against medical profession hospitals went on increasing, and in one of the research papers it was said that almost more than 50% of increase or high in fighting the cases against medical professionals. We have just now discussed about the Ego's case, Martin D'Souza's case, Sum Sharma's case. Of course, it's possible to talk for about an hour or so for each judgment, because these judgments, if you go through and read, they are excellent pieces of actually deliberation on this particular subject. We already have discussed the Aruna Sharma's case. We all know that this lady was a nurse. Here when she was young, she was about to get married to a young doctor, but an attempt of rape on her, actually, and then throttling her, led her to the vegetative state and go to the hospital to revive her. She remained in the vegetative state for several years, and finally, though she died, her friend, ex-best friend, P.T. Virari, filed cases in various courts and finally the Supreme Court, trying to find out whether the Honorable Supreme Court can allow her to die. So, right to death, whether that is. Obviously, in India, we don't have the right to die. So, I think by this time, everybody is quite clear. And only thing is that the passive euthanasia, by this time, euthanasia is particular term is not followed. That means, if the patient is dying, doing something active. Now, since I'm a surgeon, I know what are the processes and what are the processes for and what treatments they give to the patient. We can say that the actively managing a serious patient, when the utility of the treatment is known to the medical professional, then in such a case, the patient can be allowed to die, but there is a process. The process is that legally there must be a documentation that any kind of a further treatment is not going to the patient. So today's position is that the passive euthanasia is allowed. So this is about Aruna Sharma's case. Then other two judgments are Vishen Rao versus Indian Super Specialty Hospital. So here, it's difficult to get evidence of inspired medical conditions, because the concept of negligence is very new. We in India, the peaceful society, has a faith in doctors and medical professionals. So it's difficult to accept that doctor can err. Now here, evidence might not be said, possibly might be helpful in defining the concept called res ipsa. In law students, you are aware that what is this concept? That means when the obvious things are there, evidence is not necessary. So this Vishen Rao was an English supervisor. 2010, they said that this concept is applicable in case of this operations. Then it was widely discussed. This common cause versus Union of India was discussed while discussing about the advanced treatment. But though this is in 2018, this concept is still to be progressed. That means the society at large is not aware of the advanced treatment, but that definitely will help, and that takes care of the dignity of life. And one more case, that is Raja Abrasian Hospital versus Master Rishabh Sharma. Obviously, this is the second case in 2019. After 19, I think 67th case of Dr. Bushi versus Dr. Bole, which says that duty of care is very important in case of preoperative care. So these are certain cases which the Supreme Court has come out with laws and coming out with what exactly can be the greatest legal person which is allowed in for his orders. So what are the challenges that are faced by medical practitioners? Usually what happens, the medical professionals, they fear lawsuits. Obviously fear of prosecution also there. There are certain percentages of some of the research papers aside. So legal action against the medical practitioners when they fear a law, that means they need to take care by treating the patient. So they need to follow the legal principles, the guidelines which are set by the Code of Medical Ethics 2002 and the various principles which have been discussed and put forth by Honorable Supreme Court of India. They need to be followed. Taking care of the legal aspects of the patient treatment. Euthanasia debate. With this program itself, we have a good debate, and I'm very happy with the papers which I heard when I joined. The good quality of discussion is there, and this was all National 2011. This case we are aware, and we have already just now discussed about it. So this is a landmark, and we can say the vehicle in this particular landscape of dignity of life. What are the findings of this particular case? Instead, in spite of or despite people bringing this must be actually certified by doctors that now she is not going to, or the patient is not going to have a useful and active life. Any withdrawal of life support requires prior approval from the patient. Now, you will find that in various medical conferences and even our conferences, it is mentioned that PNR, do not resuscitate, PNOR, so various names are given. So do not resuscitate is the consent of the relatives, which is obtained by the patient. So what legal standing it has. Actually, this case has clarified, Shagam case has clarified that obtaining DNR is what whenever you want to withdraw this, this must require or requires prior approval from the jurisdictional high court, ensuring the independent judicial rule. So I'm not going into the details, but the point here to be stressed is the DNR consent is here the dignity of the dying person is protected, and the concept called end of life care. So this, though it is being discussed all over the world, in India also, this end of life care has now become an important concept because because of many reasons, patients die. So I was a CEO director of one regional cancer hospital, and you all know that the cancer patients, whatever the person is educated or whatever standing in the society he or she has, the patients come at the stage of patient in the hospital, and then it's very difficult to treat the patient, and then one needs to discuss about the end of life care with the relatives as well as the patient as well. Now, what is the legal status of euthanasia? I think I will skip this. Passive euthanasia is accepted. Active euthanasia means killing the person even though he is delayed and kills it in writing. It is illegal, it is not allowed. Dignity in life and death, yes. Law will not record happen to the patient and the issue of death. This is the theme, quite important, but even the person who is not live and further he consents that in case of such situation where I will not be in a position to give consent to the treatment or even withdrawal of the consent. My legal representative will have this particular authority. So that is the dignity which the law provides when advance directives are signed. Procedural aspects in medical legal, obviously, in just short thing, that whenever such cases are brought to the hospital, the initial responsibility of a doctor is to treat the patient, stabilize the patient, and then report to the police. So, before the legal proceedings are initiated with proper documentation, only afterwards, only after stabilization of the patient. So, there is a registered, separate register, registered, initial treatment, then patient is registered, then patient police is notified, and evidence of all these documentation, photographs or whatever, X-rays, everything is preserved. And for how much time this documentation is preserved? As per the law, it should be for at least 30 years, 30 years. Now, what is the role of doctors? So as we have been discussing about the medical legal reports, they must be accurate, objective, and the documentation must be in short. Then the expert testimony, the doctors must testify in the court of law whenever they are invited to give expert testimony. And there must be a ethical balance. Now, by talking about ethical balance, patient autonomy on one side and the doctor's rights are on another side. See, what are the doctors? Do doctors have rights? We talk to the patient's rights or people's rights. So doctors do not have great freedom of business, but that there must be a balance between the liability of the doctors and the patient's autonomy. Patient can decide after listening to the details of the disease and the treatment being offered, pros and cons of the treatment, everything the doctor will have to explain to the patient and the relatives, and obtain a consent. Now, informed consent is another basic, very important this one. Samira Kohli's judgment has, on the Supreme Court, has actually come out with or have given the guidelines how the informed consent must be. And the medical professionals, for medical professionals, there is a legal boundary. That means whatever the patient has consented, only that part is the legal information. So this is in short. So there must be an ethical balance between the patient's autonomy, which is ethical concern, and the doctors of So the medical injury and investigations form the important mainstay while the dignity of life is being discussed. So independent inquiry panels and the procedural guidelines, they are the important aspect whenever the medical injury it is actually being discussed, and we can say hotly being discussed amongst the medical professionals that whenever medical accidents are there, why the doctors must be liable or why they must be legally responsible. So of course the law has answers to all these questions, and the various judgments and judgments have given the answers to all we can say the liabilities and responsibilities of the doctors. They have been clearly mentioned. So the transparency quite important, mandatory timeline important, and the patients who are dissatisfied with the outcome, they have been handed over the Consumer Protection Act as a tool for approaching the transaction, and these concerns have been taken care, and I'm sure those who are interested in this particular subject or this particular theme, they must study all the concepts. Now, moving ahead, the developments are quite important, and obviously the legal regime which is available to the patients. Obviously, there must be a balance which we have been discussing right now. Now, Bharatiya Nyaya Sanhita, DNS 2023, section 106, subsection 1, has actually come out with the graduated culpability or deaths caused by so here, this particular section of DNS has discussed and defined the graduated culpability for deaths while the patients being treated. Now, in order to discourage the harassments to resist prosecutions, reducing the exposure to the most serious criminal charges for doctors and incentivize adherence to documentation protocol is the three most important aspects. Under this, obviously, the process of the procedures which have been actually laid down in the checkup activities, this process is quite useful. And this section endorses that the process needs to be followed according to the set legal principles. Now, in the medical negligence cases, many times, because of the lack of knowledge or because of multiple reasons, there is a delay in formalizing the rules as such, as well as. So that means there is a gap between the available legal knowledge and the need of this society. In short, this is what the meaning of this particular slide is. So, we are aware that also the Supreme Court of India has been instrumental in actually filling out the gaps as such, and every now and then in various different judgments have come out with the exact procedure in case of negligence matters. Now, I am skipping certain slides because now the time is almost up. The legal uncertainty is quite important. That is, no doctor thinks that this patient should die or there should be a bad outcome. But though the intention of the doctor is not bad, still the medical professional must know that he is bound by a certain boundary, a legal boundary within which he has to perform and which he has to. So there are certain aspects that he has to keep a perfect documentation, he has to obtain certain informed consent, he must respect the autonomy, the consent must be from patient only. But because of the current scenario, doctors have not following the defense medicine. That means either it is a positive defensive medicine or negative defensive medicine. Give certain examples. The doctor, after this particular scenario, after these cases, reduces his timing of hours of practice, takes only 2 patients, then refers the patient to various super specialists. So that increases the cost of it and does not try to take the risky cases while though he is competent. And above all, you will find that the certain doctors of they are not into this function now, but they prefer some other field. Maybe sometimes they prefer law field. Now, victims of genuine negligence, they must be protected. That's the reason why the legal regime must be perfectly discussed and must be available to the patient. So here, law and medicine, there must be a relation. Now, last time also I had discussed this concept called medical legal partnership in the USA, I think for more than 20 years from now. This concept is being established in various organizations, medical as well as legal, where the medical professionals together to provide a safe patient and the patient's legal problems are taken care by legal professionals. And this is quite important as such. This balance is required. Now, certain case studies, I will just move ahead. We know that case we have just now discussed. So gross deviation must not be there. Gross deviation is got to be defined, and in case when the evidence is there, in that case, the cases must be taken care as per the legal measures. This is one case. Second case is the Kusum Sharma versus the Batra Hospital. As I said previously, institutional liability has been defined. Private healthcare has been held accountable, and the patient's rights have been saved. Aruna Shankar case we have already discussed, and there are lot that needs to be only on this particular case. There can be a day-long session which can be discussed to know the principles. And again, PILs are every now and then required to obtain under the Supreme Court's guidance so that that can be helpful to the patient. All these factors for the utility of ethical dimensions and human rights. You know that the Human Rights Declaration 1948, this has come out with the rights of human beings, where the human rights are really important. They have ethical dimensions as well, and ethics is far more important, though it is not foreseeable. These ethics or dimensions, they must be known to all the stakeholders, patients, doctors, society. So all these three must be. Now, right to life and dignity under the Constitution. This has been also discussed by various speakers. There is a right to health, right to life, right to be free from cruel treatment, right to dignity in dying, right to emergency medical care. All these aspects and dimensions we have already discussed. I think I'll just take 5 minutes to conclude this particular session. Now, right to informed consent. Please read the Savera police case. It's a judgment, a beautiful judgment. I'm sure it will get new insights of the informed consent. So this is what we discussed, that balancing patient autonomy and so this is the concept of informed consent in case of incapacitated patients. Those who cannot consent, this is the guardian of the legal representatives are appointed, and the judiciary has a place to actually see to it that this is implemented and this is taken care of, and the all legal regime is properly legally implemented. So this is quite important. We are discussing about the aspects of this. Vulnerable patients, patients who are unconscious, there is cognitive impairment, economic dependence, and even dependence and socially marginalized patients. So these are the patients who are to be protected. There must be a compassionate care, and the standards are there. They must not be exploited. So always it is a compassion. So you have heard this natural justice. So this concept is of having compassion. So compassion is at the core of the justice. So this is quite important, and the human aspect or humanity that cannot be ignored, and this is the role actually the judiciary plays. This is, I think, being discussed by the next speaker, the forensic medicine and toxicology. There is a role having the evidence that religious medicine and law, and there is a law is being discussed at in the society wherever the cases are being discussed in the social media. Now these I'm not going into much detail, but the reports, forensic reports and reports have the legal significance. Now, there are certain, of course, the concerns and the challenges. Of course, everything is affecting the people. So, we just move ahead and the medical practice and society, it is the relationship between the law and medicine. On and on, we are again and again stressing the importance of these. Of course, this we have already seen and just move forward. The public perception and media influence is quite important. So, that's the reason is the pressure from the public on various important aspects, and even the media, that actually changes or helps in evolution of various concepts that law actually comes out in community. As now moving ahead, the medical legal collaboration is quite important. There must be training, protocols must be there must be transparency. Now, you will agree that the kind of transparency we don't have. We don't have the transparency, right? In every transaction, in every aspect of life, the transparency is there. Of course, there is a lot many to talk about this. Now, this is a concept called collaborative justice. Two fields can come together, and then the issue. Now, international perspective also, there is a comparison. This we have already seen about the euthanasia. Active assisted dying is not there permitted in Netherlands, Belgium, Canada, Switzerland. Passive euthanasia permitted in India, UK, Australia, and it is not allowed in Central Asia. So this is, we have already seen this. I think a couple of slides. Medical negligence framework is in various. Again, this is a concept which can be discussed for hours. So all of this we possibly have not discussed, and even the dot law. So United Kingdom actually follows this. We have last time seen that the common law of England is our main important law in India follows the common law of England, and in UK the monoptess and dot law is used for this particular dignity of life concept to be followed. United States, it's a state-based law system is there. The expert witness requirements are there, capping of the damages, and even variation have been discussed. The alternative models are New Zealand and Sweden, where no court competition is involved. Of course, I'll be able to talk on these particular concepts for 1 hour, but these are certain models one can afterwards definitely go. Human rights and medical ethics, obviously we have seen that this is being discussed in all forums, and so this is just coming to an end. There is a need for comprehensive investigation. Medical negligence prosecution rules should end of life care and balance rights at work. So these are certain actually suggestions which I'm not going to actually go into details of that. Strengthening the medical education of people. So this is quite important. So when I actually completed my medical education and surgeon, I was absolutely not aware that there is such law actually takes care of or one must know the law. So now the medical students must know, and even there is a need for enhancing the judicial awareness and expertise. So specialized field, one has to actually have knowledge about it. So specialized medical benches, master resolution should be there, and the judgment should be there. Suppose these are certain decisions. Even patient awareness and advocacy is important. Support should be given. Important. Number of solutions are there. Depend on the awareness of the society and many sections of the society. So finally, to summarizing this, that it's a complex situation. There is involving jurisprudence. And in these complex scenarios, what has to actually, with the awareness, proper awareness, try to help further thing, actually, the society can march ahead to a good society where justice is created. That can happen only with awareness and obviously by the awareness as well as the implementation of the certain principles by various sections of society, like the professional personalities from medical as well as. So with this, let me actually stop here and I'm stopping the sharing of the screen. Right. So I'm thankful to all of you. Now, since it is not possible to actually interact with you as such, if you have any question, I will actually be able to answer. Else, I think I'm sure at least some part of it was understood by all of you. I'm thankful to all of you for patient listening, and obviously I'm thankful to the organizers for giving me this opportunity to have this session. Thank you very much.
Any questions?
Thank you so much, sir, for your valuable insights and words. We are truly blessed to hear you. Now I request if any participant has any question regarding the things that sir has shared right now, they may ask. We are open for the discourse session. There is no question from the side of the audience. So, yeah.
If I would have been given I would have asked questions. Thank you very much. Thank you. So I am honored that Shri Honorable Ambada Joshi sir was there in the session, and therefore you sir.
Thank you so much, sir.
So we will proceed ahead. I will just thank you.
Sir, if possible, you may kindly be present at this meeting as well. We request you.
Yeah, no problem.
Thank you, sir. So,
I'll be there for quality questions.
yes, sir. Yes. So, as our discourse session is over now, so we are now proceeding towards the paper presentation segment of our fifth technical session. So, for this session, I would like to clear you one thing, that the participant will get 7 minutes for the presentation, and after the 6 minutes, there will be a warning bell for the participants, and after that time they will have to conclude their paper presentation, and after 7 minutes there will be 2 bells. So may I now invite Arpita Patare, Lavanya Thakur, Harsh Harish Nirmal to present their paper. Over to you.
A very pleasant good afternoon to everyone present over here, respected dignitaries and everyone present over here. We are honored, Arpita Patare, Lavanya Thakur and Harsh Nirmal are honored to present our research paper titled Dignity of Life, a Distant Dream Yet to Achieve. A term dignity is derived from a Latin word dignatus, which has evolved over a time, being limited to only individual, becoming a universal value belonging to all humans. A special credit goes to philosopher Immanuel Kant, who has redefined the word dignity in his in his book. By following both methods, that is doctrinal and non-doctrinal process, we have aimed for examining two main issues. First, a gap between Article 21, guarantee of life, and its ground reality in the healthcare sector. Second, lack of public awareness and as well as the hurdles in the organ donation and the healthcare rights. This here is a legal framework which governs the healthcare sectors in India, which comprises of first, fundamental rights mentioned in the Part 3 of the Indian Constitution, and second, directives, principles of state policies mentioned in the Part 4 of the Indian Constitution.
As you might be aware that Indian Constitution does not provide any direct law related to dignity of life. In this context, case of Maneka Gandhi versus Union of India 1978 holds its unique importance. It was the first case in which the scope of life under Article 21 was primarily extended by the apex judiciary, as the judgment held that personal liberty is not just a mere physical existence, but Article 21 includes the right to live with human dignity. Now moving on to the case number 2, Badwa Mukti versus Union of India in 1984. The judgment throws light on the interpretation of dignified life under Article 21. It highlights the importance of safeguarding children's rights, including education, well-being, and it also gave an insight on the wide scope on dignity of life. It also expanded Article 21 to include dignity, shelter, healthcare, and nutrition. Despite a strong constitutional framework protecting healthcare under Article 21, a sharp contrast can be seen in this promise. When it comes to reality, public hospitals often deal with overcrowding, lack of specialists, and insufficient diagnostic facilities. Now, let's come to the topic of organ transplantation, which is regulated under the THO Act 2011, that is, Transplantation of Human Organ Act, which even resulted in formation of NATO, that is, National Organ and Tissue Transplant Organization. If we come towards the reality of the situation, away from the books of law, the survey that which we have conducted give us an insight about the actual prices of organ transplantation and donation in India. Out of 100, our survey shows that 67% of the respondents are unaware about the THO Act and its regulation, which questions the awareness in the ground level. And around 83% of the respondents believe that citizens of India are at high risk of exploitation in organ transplantation.
Coming further, you can see here some statistical analysis which we have procured from the official website of NATO. As you can see, the number of transplant as well as donations in our country are profoundly lower to meet the enormously rising demands. The bad fate of our country also lies in the fact that that the donation rate in India is 1 per million population, whereas countries like USA as well as Spain have managed to reach a donation rate of 35 to 50 per million population. Coming to the next slide, you will see the data related to living transplantation performed in our country. Some might feel that this data is comparatively having higher numbers, but the reality lies in the segment that these donations are highly restricted to inter-family donations and are still not sufficient to meet the rising demands. Following here is the supply-demand deficit, which can give you a clear view of the issue. For instance, let us consider year 2016 and 17, over 5 lakh people were waiting for organ transplantation, out of which only 15,560 received them. That is, roughly, we have only managed to reach 3% of the requirement. And to counter this, we have proposed a hypothetical untapped potential of our country. Considering year 2013, 1,50,000 people were awaiting for transplant, out of which only 1,177 received them. And according to the data obtained through web source, 19.5 lakh people died due to heart-related issues in year 2013 and 14. Now, considering them as the ideal donor, if we could manage to bring only 4% of them as volunteers for disease donations, then we could have easily reached the transplantation limit of 1,56,000. Through our research, we have proposed a reimagined model of patient care in our country, and we have three suggestions to give you all. First, the unilateral decision of doctors without consent of families of patients can be avoided by developing an interdisciplinary teams which will be mainly comprising of counselors as well as social workers. Second, by proposing a fee concession structure to chronic disease patient as well as patient awaiting organ transplantation, we can uphold the financial dignity of the patient and their family, as well as some part of the palliative care can be given to the patient by obtaining Kerala-based model to uphold their psychological dignity.
In order to cross-verify the ground reality, our team has also conducted an interview of a renowned doctor, Dr. Chandrasekhar Saban, who has also been served as RMO, that is Resident Medical Officer, for a decade. He suggested a highlighted of emphasizing of the awareness campaigns and as well as suggested the patient counseling station as well as for their families. He also special mentioned about the need of speeding of the documentation of the procedure. Further moving to conclusion, we come to a conclusion that dignity of life is not entirely absent, but is a distinct dream for many of us. This can be overtaken and overcome by a reality effective implementation, awareness programs and intensive healthcare sectors. Thank you. Do anyone have questions?
The ground level awareness should be created from the rural to urban, because the organ transplantation we talk only in urban areas.
What would be your suggestion to create the awareness from the rural level? Because in our country, major population resides in rural area. Can you suggest?
Through the interview of the doctor, we have came to know that effective campaigning is the only solution. According to him, the effective campaigning and counseling are only solutions to bring more volunteerism in the patients.
Any further questions?
Thank you so much, presenters. That was really a detailed research. Now, may I request Professor Dr. Girbani ma'am here to share her valuable insights as well as the feedback about the session and the presentation. Ma'am, over to you.
Thank you, Misha. Now we have come to the close of this technical session, and we are actually deeply enriched with the insightful deliberation by the resource person. In this technical session, resource person has guided us on conceptual evolution of medical negligence and its judicial response, through which many ethical guidelines are set by the court. During his discourse, he has highlighted on what is medico-legal case, what are different types of medico-legal case, what are the doctor's responsibilities. He also has discussed 40 years Indian judicial landscape on medical negligence and explained how this concept is evolving over a period of time. With reference to three landmark cases, especially Jacob Methu's case, Kusum Sharma's case and Martin D'Souza's case, which have shaped the medical negligence law in India, he has focused upon medical professionals' accountability. By referring to many other cases, he brings our attention towards how through the judgments judiciary is balancing compassion and accountability. Besides this, even he has covered the topics like what different challenges medical professionals are facing, dignity of life and euthanasia in India, procedural aspects of medico-legal cases, along with recent developments and legislative reforms and future directions and suggestions. These all things are covered by our speaker during his discourse. And in this session, I would like to conclude by saying that this session reminded us that law does not merely regulate the life, but protect dignity of individuals. So I express my sincere gratitude to our resource person for this valuable insight. Along with this, in this technical session, three students, Arpita, Patre, Lavanya and Harsh, they presented their paper on dignity of life and a distant dream yet to achieve, in which they started with the research problem. They highlighted on legal framework governing healthcare in India by reference of many judicial pronouncements. They even highlighted on crisis of organ transplantation in India with statistical analysis. And finally, they have given their valuable suggestions. I appreciate and congratulate the students who have presented their quality research work and contributed in the seminar. I thank once again all of you for being part of this technical session. Thank you.
Now, as we have reached to the end of the session, so here I am here to conclude and I'm here to propose the vote of thanks. So firstly, I would like to extend my heartfelt gratitude to Dr. Shri Santosh Kadre sir, who shared his valuable time and insights with us, who helped us to know a lot about the legal medical part of the field. Secondly, I would like to extend my heartfelt gratitude to Honorable Justice Sri Ambadas Joshi sir, who really blessed us with his gracious presence on this occasion. Thirdly, I would like to extend my heartfelt gratitude to Dr. Pratibha Gidwani ma'am, who from the beginning of the session who introduced about the topic and the theme of our fifth technical session, and also she shared her feedback about the session as well as the presentations. I also want to extend the heartfelt gratitude to the presenters of the session, all the three presenters who presented so well and contributed and suggested a lot of things in the session. Last but not the least, I would like to extend the heartfelt gratitude to the research club of our college as well, who organized such a beautiful program in which people from all over the part of the country are here to present their paper. And also I would like to thank the volunteers and the audience who are here tirelessly since the morning. Thank you so much. And now I request all of you to proceed for the lunch that is there in the campus itself, and then as per the schedule, kindly be here in this room itself. Thank you so much.